Anybody in our audience has not already put their cell phones on vibrate, I would be truly grateful if you did. I'm Judge Traver. I'll be presiding over this oral argument session. Joining me to my right is the Honorable Josh Mize. To my left is the Honorable Roger Ganem. Mr. Tinker, the default is going to be 5 minutes for rebuttal. Would you like to move that up or down?
5 minutes is fine, Ron.
You may proceed.
May it please the court. Good morning, Mark Tinker on behalf of People's Trust Insurance Company. We have kind of what I think is a unique case today in that this is an issue that two districts have already written on precisely the same issue as is involved in this case. And I say it's precisely the same because the insurance policy provisions are identical, the ones at issue, and the underlying facts as far as they're relevant to the policy provisions are also either stipulated or as close to identical as can be. These are cast iron pipe cases. As the court's likely aware, a lot of houses, most houses built before 1975-ish, all have cast iron pipes. That's created an issue because over time, cast iron tends to rust, corrode, deteriorate. And so a lot of homeowners insurance policies, because of that, have different provisions in them to account for the fact that this is kind of an inevitable situation that's going to arise. What the Gunsers did with their policy with People's Trust is what the same thing as has occurred in prior decisions like I referenced in Dodd.
Counsel, let me ask you, do you think that is active nature a term of art?
I don't believe so. It's something as the Gunsers Council is quick to point out, it's something that's not defined in any legal dictionaries and any regular dictionaries. So what
is it used colloquially by people in conversation as a term of art?
As I don't think you look at it as a term. What it is if somebody says an act of nature, an act is a term that's used colloquially. Nature is something it is as well. So what you look at it and say, if I say to the man on the street or the woman on the street, is this something that people did? Is this something an animal did? Or is this just an act?
I guess what I'm saying is if you were in normal English language, if you use the term act of God, I think everybody would agree that that's, they don't just mean a combination of the words act of God. Act of God is a specific term people use, as a colloquial phrase.
It is.
And I know you disagree that act of nature is synonymous with act of God, and I certainly see why based on the context of the contract. I'm just saying, do you agree it is a phrase? Like that is that in conversation in the English language, people say the words act of nature as a colloquial phrase, like not necessarily synonymous with act of God, but like act of God is a colloquial phrase. Act of nature is a phrase people use. It is not merely a combination of the words act and of and nature.
I don't believe act of nature is a colloquial phrase. It's not something that you normally hear people use to say it, something that they're going to know what that meaning is. What it is, and I want to be clear about this because you bring up act of God, and the Gunsers have been very, have brought that up quite a bit in their briefs, and they've offered definitions of it, different cases defining it. This policy does use the phrase act of God in other places.
Okay, so no, I'm not asking you whether they're the same. I read your brief as to why they're different, and the contract seems to use them differently. I'm just saying, is it a phrase? And I guess you're saying no. And the reason I ask is because, as a user of the English language, I mean, I recall hearing people use the phrase act of nature, and it kind of goes to kind of a what I think is kind of a deeper issue of textualism and contractual interpretation. And what I mean by that is there are some words that would require no explanation, right? If a contract used the word dog or road or plane or human, right? We wouldn't resort to like some detailed, interpretive analysis to determine what those mean. We would just say any user of the English language in the year 2023 or 2021, when this was written, knows what dog means, right? And it just has its plain meaning, and we would not go farther than that. On the other end of the spectrum, there are words that clearly have different meanings in different contexts, and maybe different communities use, maybe different age groups use them. Young people say a minute to mean a long time. People of our age group probably don't do that, right? There are phrases that are more common in certain cultural communities than other communities among certain age groups. And so there are certain phrases in the English language and words in the English language that we would need to resort to some kind of interpretive analysis to derive meaning from them. And there are other phrases that we just wouldn't. And I'm trying to figure out where on the spectrum active nature lies. To me, that is a phrase that I've heard used as a user of the English language. I've heard people use throughout my life. I wouldn't say it's so clear like dog or human, where it requires no interpretation at all. So how do I decide kind of where on the spectrum that term lies? And if it lies, as I think it does, in a place where some interpretive analysis is necessary to derive meaning, how do we decide what the appropriate ways to do that is, right? Like, for instance, some phrases go in and out of fashion throughout time, right? I mean, there are certainly phrases that were a lot more common in the 1950s or the 1800s that we don't use anymore. So, and certain communities might use them longer than others. How do we kind of determine what the plain or ordinary meaning is of a phrase that might not have the same meaning to every single person, or at least the immediate same meaning to every single user of the English language?
I think the way you do that in this case and in the terms of this policy is you have to look at the company it keeps. You have to look at it in its full context. It's not just active nature sitting there by itself. It is in a sentence, whether caused by human or animal forces or an act of nature. So if you look at that and just the plain reading of it, if somebody's trying to figure out, does this exclusion or does this provision apply to my situation? Was it a human force, an animal force, or an act of nature? If you can answer any one of those yes, then you know that it applies. And if we look at this in what both the fourth and third districts, or fifth, I'm sorry, the fourth and fifth districts have done, they've said rust and corrosion is just something that naturally occurs.
But what the fourth and fifth district did is kind of what I have a problem with. They said, here's the definition of act, and here's the definition of nature, and we're going to put them together. And that doesn't make sense to me. Like, you would not do that for act of God, right? And again, I'm not saying they're the same. I'm just saying they're both phrases, different phrases with different meanings, but phrases, right? And so, if you were to say when pigs fly or between a rock and a hard place, you would not just look up the definitions of those individual words and put them together. You would say this is a particular phrase that has meaning in the English language. So I guess what I'm saying is, like, how do I derive that meaning? Just to say it's different than act of God, like, I get it. I can see why you say it's different, but just the fact that they're different doesn't tell me what it means.
But I think the reason that the courts have taken them, well, first of all, if you look up active nature in any dictionary, it won't be there. That's why they look at it and try to say, what does this phrase mean? They look at the two terms. And the reason it's been broken down where they say they've looked at act is a lot of it is because of the way it has been argued that rust and corrosion isn't an action, that it's just a process. And so there's been kind of nitpicking at, well, that's a natural process, not a natural act. So the way that learned counsel have been trying to find coverage in the face of this phrase is to try and nitpick the words that are there. But what the fourth and fifth districts did is they said, well, it is an action. Rust and corrosion is an action. It's the elements acting on the iron. That's what makes them rust. We know it's an action because you can protect iron. You can paint it. You can bring it indoors, protect it from the elements. You can do things to stop that from happening. So we know it's the environment, the nature acting on the iron that causes this to occur. So that
just uses it in the literal sense. I guess what I'm telling you is, I, as a user of the English language, have heard this used as a phrase throughout my life. Okay. What do I do with that? Because what you keep saying is, well, just look at the actual words. Act means this, nature means that. And this is clearly something that happened as a result of an act that occurred in nature. And I'm asking you so this is like the fourth time I've asked it, so I'm going to actually address it. As a user of the English language, I have heard that used as a colloquial phrase throughout my life. It's hard for me to accept that it just has no meaning as a phrase and that it's just a sum of its parts. What do I do with that?
Well, I think it does have a meaning as a phrase. It is an action of nature. So if it's something's just sitting there and nothing happens, that I suppose you could say that's nature, but nothing's happening. There's no action taking place. There's no natural force occurring. So it's just an act of nature. I apologize if it sounds like I'm not answering your question, but I think that is the phrase, is you look at it and say, is nature acting? Is it an act of nature? The same way as you have human forces and animal forces. Animal forces isn't really a phrase that you can look up in the dictionary, but if you just say animal, that doesn't mean anything. But
animal forces is not a colloquial phrase used in the English language, right? Animal forces really just is some of its parts, right? And that's the point. Some phrases are set apart and used in English language differently than merely the sum of the words in the phrase. Do you see what I'm saying? Animal forces doesn't fall into that category. Act of nature, I think, does. And the way I've kind of heard it used throughout my life is, some surprising natural event, like a tornado, right? That would be an act of nature. But rain would not. Like if it just rained outside, you wouldn't say, oh, that's an act of nature. But if a tornado suddenly randomly hit, he's like, well, that guy was killed by an act of nature, right? Like it seems to be used in the English language as some surprising or unexpected natural event.
And to me, that would be turning it into act of God. That's the way that that's colloquially used. And that's the way that this policy uses it 3 times in the policy. It uses the term act of God in other places. Here, it is just an act of nature, which to me, rain is an act of nature. It's something that man has no.
Have you ever heard anyone use the term act of nature to refer to some totally expected and normal natural process?
It's been used. I mean, when we first started this discussion, I haven't heard people use the phrase that way, saying an act of nature. That's not something that naturally flows off my tongue in normal conversation. I don't hear it a lot in normal conversation in general. I think it's something that, courts have looked at a lot, and they have applied it to snowstorms, to roots growing, to things that aren't an, oh my God event, not an act of God. It is just something that naturally occurs that man has no role in.
Litigated. Oh, go ahead.
I'll take up the time. I'll just ask more questions. I'll give you an example, right? You could imagine definitions of these two terms that are distinct but not mutually exclusive. So different but overlapping, right? So imagine the, plane is flying and crashes and lands on one very unlucky person, right? You wouldn't say that's an act of nature because it involved an airplane. You'd say, oh, it's just a very sad act of God. If a huge bird was flying overhead and had a heart attack and landed on a person and killed them, you might say that's an act of nature and an act of God. You see what I'm saying? Just because they're different doesn't mean they have to be mutually exclusive.
I agree. And I think act of nature is, and especially in this context, we're talking about a homeowner's insurance policy, and in the company it keeps, and when that sentence with the human or animal forces or act of nature, I think act of nature is broader than act of God. And act of God is, like you said, the oh my God events. That's why, I think the word fits it there. An act of nature is just anything that naturally occurs. And that's what the courts have looked at and said, rust and corrosion, people don't play any role in that. It just naturally happens, and it's inevitably going to happen. If you put rust out in the elements, nature is going to act on the iron, and that's just what happens. So it's an act of nature as opposed to a human force or an animal force.
You've litigated this issue statewide, probably not as much as your opposing counsel. In any of the cases that you've litigated statewide, and there are, dozens of them that are in the record, have you seen a construction of act of nature that's different than the one that opposing counsel is tendering in this case?
So different than
act of God is synonymous with act of nature. Have you seen a different construction of act of nature?
No,
other than the one you're proposing.
Other than what I'm.
In other words, has there been any? I think what you're doing has there been any construction in favor of the insured other than finding it synonymous with act of God?
Not that I have seen, Your Honor, and I know all of the orders that are in the record and all the cases. I believe we have 6 of them at the DCA level that Mr. Nation and I have argued together that have looked at this issue. They've all come down on one side or the other, saying it's either just a natural process, gone in line with what, Dodge, I believe, was the first one that started that in the 4th district, have gone in line with that. A lot of trial court orders have said, before Dodge said this is equivalent to act of God, or even after Dodge, if they didn't find, they said, I understand that I'm bound by God, but for Dodge, I would have found this to be an act of God. So that's the only other construction I've seen, is to equate it to say, this is something that has to be one of those, oh my God events.
Counsel, you've argued that dictionaries are of limited usefulness here because we won't find act of nature in a dictionary. Is it useful or appropriate to look at the insurance policies issued contemporaneously by the peer insurance companies? In other words, should we look at other policies that exist at the same time and how they use similar language? Is that helpful here, and is that appropriate?
I don't think it's appropriate here because I don't think it's ambiguous to begin with. And that's the only time that you start resorting to rules of construction like that. Even if you're talking about getting to dictionaries as step 1 on going to looking to other policies, the Supreme Court tells us that if it's not ambiguous, then there's no reason to resort to any rules of construction. Just apply the contract as it was written. And here, I mean, I know I've said it a couple of times, but we have the phrase act of God used in the policy 3 times. This is different. This is act of nature. The DCAs that have looked at it, now we've had 4 cases, I believe, that have looked at it and all agree And even amongst the decisions coming out within the same districts, there have been actually diverse panels among them. So we have quite a few judges looking at it saying, this is just a plain language phrase. There's no reason to look to anything else. It just means that it's something that naturally occurs. And so that's what we believe that the court should do. I don't believe that there's any reason to look to other policies.
You are about to be into your rebuttal time.
Okay, I would like to just quickly bring up, there are, of course, the other issues. The other is the issue with the tear out, whether that is even covered. We believe that the court should follow what the Penitentiary Court did out of the fourth district, and then just about 3 weeks ago now, what the third district did in Banks. That decision did just become final last Friday because the time for rehearing expired on that. So we believe that the court should follow those decisions. As far as whether tear out is even covered by this policy, it is not, because of what we've been talking about, because this water damage exclusion endorsement applies. It makes the loss otherwise excluded, and therefore there is no coverage but for what that limited water damage endorsement provides, which is only for water damage. It does not provide any tear out coverage. And then the other issue is, we did raise, this is kind of odd, we did raise a few issues asking for a new trial as far as issues that occurred at trial. The answer brief didn't even address them, so we didn't bring them up in the reply because there was nothing to reply to. So I did just want to mention that they're there, and I'll just rely on the briefs for those.
Mr. Nation, this is a cross appeal. Would you like to reserve any time?
5 minutes, but I don't know that I'll need it, but that's fine, Your Honor. And first of all, thank you for accommodating me. I will just jump right in on these issues. The natural process and act of nature, they're materially different. An act of nature is a
Mr. Nation, can you start by addressing Judge Traver's question? So out of all the trial court orders that went in your, in the insurance favor, did any of them construe act of nature to mean something other than being synonymous with act of God?
They were all the same. And even after Dodge, and this is unusual, after Dodge came out, I had multiple trial courts say, but for Dodge, and they said, I disagree with the analysis and conclusion in Dodge, but I'm bound by it. And but for Dodge, I would have found in favor of the insurance. The only
on the basis that act of nature is synonymous with act of God, or did any of them give a different construction?
No different construction.
Well, the reason I ask is I really had a problem with the way you briefed the case. And what I mean by that is you kind of staked everything on act of nature being synonymous with act of God and really proposed nothing in the alternative. In other words, I think on the way the burden works, if there's any reasonable interpretation in favor of the insured, we have to follow it, or we have to, construe the contract that way. And you basically said act of nature is synonymous with act of God. But if we disagree with that, you didn't really explore any possible alternative interpretations other than it being synonymous with act of God that we ought to consider. And so I kind of felt like the analysis was incomplete in that sense, because I think that the case under the contract for act of nature not being synonymous is pretty strong. But to me, that just didn't. There was analysis left to do after that. It didn't seem to me that just because they were different, that there wasn't, even if they're different, that there isn't some analysis left to do as to what else it might mean or what other possible interpretations the term might have.
I understand you and I hear you loud and clear. I think the way we address that is counsel is correct. We look at words are known by the company they keep. And so it says in the exclusion, any human or animal force, that's an external force, something external to the pipe acting on, or the plumbing system acting on it, or any act of nature has to be something external. Here we don't have anything external, but I don't know how an act of nature is anything other than an act, like a tornado, a one-time event. It's extraordinary. We don't know if it's going to occur at a particular location or not. And with a natural process, we know it's occurring in that courtroom right now and in this room right here, right now. It's always occurring. It occurs over a long period of time. It's common and it's foreseeable. And this insurance policy specifically granted coverage for losses caused by wear, tear, deterioration, and corrosion to a plumbing system. And then they try to hide their exclusion in this act of nature, when the exclusion they deleted from the policy says act of nature or otherwise caused. And so they made it clear in the exclusion that they deleted and replaced with this endorsement that it was something act of nature and otherwise caused, or obviously something different. And I would point out, and you are correct, Judge Mize, some communities do not want to say act of God. In this policy, if you look at the dates that each portion of the policy is written, they're written at different times. So they're going to be written by different people. And this endorsement was written at a different time. And so I don't, whether they're synonymous or not, this policy treats act of nature materially different than a natural process.
So are you saying that the use of act of nature, as opposed to act of God, might not reflect a difference in the intent of the drafters, but just the fact that that portion was drafted at a time when our society had become more secular? As it carried over older portions of contracts from before that happened?
Yes, and if you look at the date at the bottom of the policy itself and the endorsement, they're different policies, and we know they're written at different times by different people. And an act of nature is a phrase, first of all, to get back to what originally was said, is a phrase. And it clearly is different than a natural process. They identify natural processes and then try to put them in the exclusion of act of nature. And the fourth in Dodge, and I would say I had won this issue 21 times. The only time I lost it, the first time was Dodge, but I didn't lose it. I got called after somebody else had tried to plow that field. And then I got called in to deal with that issue. And Dodge, if you look at the Dodge opinion, I have never seen an opinion written like that ever. 8 times they say we're going to interpret the phrase act of nature. And then they get to it. They ignore blacks, they ignore couch, and they say non-legal dictionaries do not specifically define the phrase. And they went right there, and then we ended up with the definition that they've cobbled together. And they didn't say that that was the reasonable interpretation. They specifically said it was a reasonable interpretation. Well, clearly there's more than one. You've got trial court orders all over the state saying a natural process is not an act of nature. Time and again, before and after Dodge. At best, it's ambiguous, especially given the fact that the one that they took out said otherwise caused. Let me check.
Counsel, when I look at the Black's Law Dictionary definition, I see, if I look at act of nature, it tells me see act of God. I look at act of God and it then gives the definition and then it says also act of nature. But in this policy, regardless of when the different sections were written, isn't the use of act of God elsewhere in the policy, doesn't that take synonymity off the table? In other words, the basic canon of consistent usage says if you use different words in different parts of a contract, they are to be given different meanings. So if act of nature doesn't mean the same thing as act of God, where do we go to figure that out?
We can look at what a natural process is, and you can see a clear distinction between an act of nature. Because the definition that Dodge had to put together to come up with the result that they put together gives you one clear answer.
Counsel, I agree with, I understand your criticisms of Dodge. The problem is you staked everything on them being synonymous. And in other words, if we decide that based on the contextual usage in the contract, they must be different, that they're not synonymous, that's not a reasonable interpretation. You didn't tell us what a reasonable interpretation might be other than that. You just staked everything on their synonymous in a contract that appears to use them differently.
The way in which they would have to be different is it has to be an external force, a force being applied on it at a particular moment of time. Any human or animal force. So a human force, a nail through a plumbing line. An animal force, a raccoon chewing through a plumbing line. Those are external. They happen at a moment of time. We have natural processes occurring to every place over a long period of time, and it's foreseeable. And at a minimum, the way they wrote this policy, it has to be ambiguous. I cited a case from the first DCA Killern where the two lawyers each walked in with one trial court order in their favor. And the first DCA said when two trial courts disagree as to the interpretation of a single clause, that's evidence of its ambiguity. We've got 21 plus. We've got the Dodge trying to make a reasonable or trying to make an interpretation of it. And in doing so, point out clearly that that term is subject to more than one reasonable interpretation in their opinion itself. And whether it's synonymous with act of God or not, it is not anything like a human force or an animal force. And
How would we describe something that occurs naturally that is foreseeable and preventable? In other words, and I'll give you some examples. Some come from the case law that are cited by your colleague. A slow, gradual accumulation of snow on a roof that ultimately causes a cave-in. A tree root that grows into a sidewalk or a structure and ultimately disturbs the structure. Shifting earth, albeit not earthquake, but shifting earth under a foundation. I'll add a couple of others. What about mold growing externally on the side of a house? What about a tree growing up through a crack in a backdoor patio? In those scenarios, those are foreseeable and they're preventable. Aren't they also an act of nature though?
They may be, but they're materially different. They could be, I don't believe under Black's or Couch, they would be considered an act of nature. But even if they were, those are preventable. Rust, wear, tear, deterioration, corrosion are not preventable. If you can't stop them, it's occurring right now in every house. And the difference is this policy specifically granted coverage for those things. And if you have wear and tear to a plumbing system, they specifically spell it out. They identify it. It's foreseeable to them. They know it's not stoppable or preventable. You can trim a tree. Snowstorm is a snowstorm that occurs at a particular moment in time, just like a tornado or flood or a hurricane. These things, rust, wear, tear, deterioration, and corrosion are not. And here they are trying to hide this elephant, this grant of coverage.
I mean, rust is definitely foreseeable and preventable. My great grandmother's cast iron skillet says that I can easily prevent rust. Now, I understand that your argument might be different as it relates to the inside of a plumbing system, and I'm not putting you on that particular spot. But I guess what I'm asking is, if I look at the universe of act and God and act of nature, I suppose I'm struggling to see how an act of nature can't be exclusive of an act of God, but still caused by nature or still be naturally occurring, which is the ROSA definition. I'll grant you that Dodge is probably a little bit imprecise.
Okay. The way that I would address it is this policy. If you look at how they use act of God and how they're going to try to use act of nature here, they're the same. They've treated it the same. They're written at different times, obviously, and different communities do address that issue very differently. And in granting the coverage at a minimum, when they're going to exclude it or try to, then they need to be able to point to what the specific grant of coverage was and say, that's what we're looking at in this circumstance. And they had done that earlier with act of nature or otherwise caused.
So it seems like your best argument as it relates to distinguishing ROSA is that, yes, judges, that's a contextual clue that you can use, but you shouldn't use it here.
Correct.
And why is that?
Because of the way this policy is written, and you've got to treat it human force, animal force, act of nature. Force and act has to be an external force if you're treating words by the keeping the company they keep and treating them the same in that context.
So if we're going to use them synonymously, what if a riot breaks the plumbing system?
Human force.
All right.
And that's external to it. And that is going to trigger that exclusion. Or animal force. I mean, it's clear. It can be, the only thing it's talking about is a raccoon, a squirrel, a varmint, a bear, something breaking something, and you have a plumbing leak. That's excluded. Those are materially different than what People's Trust says is an act of nature. The definition I'm giving is similar. It has to be an act, has to be something external to it, and has to occur at a particular moment of time. Otherwise, it's a natural process, which is different than those things. And they can't, I don't know how they can get away from that. When we look at what trial courts have done, that is a reasonable to do. And we look at what other insurance companies do. We're having this discussion. We know many trial courts disagree with People's Trust from all over the state. And in doing so, you are allowed to, under Anderson versus Auto Owners, look at how other insurance companies have dealt with this precise issue. And blacks, we can't ignore blacks. We cannot simply ignore Couch on insurance. And Couch tells us that those natural processes are different than an act of nature. And I think I've quoted that in there. In this case, and Dodge in particular, they abandoned that. And I think Couch on insurance has been cited hundreds of times in construction, including the same day in the Triff case out of the 4th DCA, where they interpreted the phrase false statement. And they went in and used that dictionary.
You're into your cross rebuttal time. Would you like to keep going or do you want to wait?
I can wait. Thank you.
I think a lot of the argument that's been made, and particularly in context of, I know Judge Myers, you've been looking for what is this third option, you know, as opposed to how it was argued. I think it's been said over and over that you have to look at this phrase in the company it keeps in the context of what's around it. And one thing that I think is telling is there's human forces, animal forces. This doesn't say force of nature, natural force. This is an act of nature. I think it's important that we're, you know, in the context of what Mr. Nation was just arguing, he's saying this has to be some big event. This has to be, you know, a discrete action that's really, you know, impacting these pipes. That would have been a force of nature, I suppose the policy could have said, but it doesn't. It chose to say human forces or human or animal forces are an act of nature. And an act of nature, as Mr. Nation argued it, he said it needs to just be some sort of external action, external thing acting on these pipes. And Judge Traver, as you mentioned, you know, the fact that this rusting corrosion is preventable, to me, says that there is nature acting on the iron, because if you protect it from nature, you're making it stop, make it not happen, or you can slow it down.
What if it wasn't an iron pipe? What if it was a steel pipe? You know, and say the steel was contaminated. Okay, so it rusted much quicker than normal, or it was just weaker. And over time, gravity made the pipe just collapse, right? Would we say that was an act of nature because it was gravity, or would we say it wasn't an act of nature because the steel was contaminated?
I think, well, you're getting into it would be a causation question at that point. Why is it that the pipes failed?
Well, it's both, right? It was more susceptible to gravity. I'm telling you, for purposes of the hypothetical, it was more susceptible to gravity because the steel was contaminated.
And I'll tell you that is actually the reason that this provision is in the policy, that it does, you know, instead of just leaving those exclusions, you know, all those paragraphs as they are, the reason this ending sentence is there is because of issues like that. And there's a case that actually addresses it. And the fact pattern very quickly is there was somebody driving a nail through a wall, managed to put the nail through a pipe, an iron pipe that was back there. And the pipe, because of that nail being there, rusted where it ordinarily wouldn't have, and ended up failing there. And so the question became, was that why did the pipe fail? Was that because it rusted? Was it because of rust or corrosion that would have put it in the exclusion? Or was it because of human negligence? So this is there to prevent that double causation issue, to say, well, is it because of human forces, animal forces, or an act of nature? Any of them qualify regardless of which one it is. So that pipe with the nail through it that was because of a human force driving the nail, and it was the natural rust and corrosion that occurred in act of nature. Both of them bring it within the exclusion. So that's a roundabout way to answer your question. That it depends on the causation of it.
Is someone, so a nail involves force though, right? My example did.
Correct.
So, okay, so you put a nail, because it's human force, right? Right, a nail going into a pipe involves human force. Contaminated steel didn't involve any force. Somebody just misplaced the formula of the steel. Right now it's weaker than it otherwise would be.
Well, I believe you just answered it. If somebody did something to contaminate the steel and that's what made it be weaker where it ordinarily wouldn't have, was that a human act or
Does
was
that
it human
involve
force?
force? Does
Correct.
that involve
Probably.
force if the steel just made incorrectly?
That would be the causation issue. Probably not, because the policy says human forces. It
Okay,
doesn't
but
say natural force.
But the gravity part is still, would that not be an act of nature? It's gravity.
If that is what made it fail because it got weaker there, and if gravity is what made it fail, then it would come back within the exclusion again. And again, so I think, like you said, the human just contaminating probably wasn't a force. That's why the policy uses
But
force.
it seems like that construction is anything that involves nature, right? There could be, because I get that, you have human force and animal force, but there could be a whole other world of things that, leads to defects or leads to failings. That involves some natural process, right? Gravity or corrosion or some chemical interaction. So your construction essentially seems to be that there can be a whole universe of actual causes, but if they involve a natural force, that's an act of nature.
If it is something that naturally occurs, that has humans play no role in it, if it just naturally is something that it's nature acting on whatever it is that fails, then yes, I believe it does fall within the exclusion.
One last question. Does the phrasing human or animal forces or act of nature, does that exclude any cause of pipe failure? In other words, if there's pipe failure, is it excluded based on those terms, or are there causes that wouldn't be covered by those terms?
I mean, I would be talking hypotheticals where we dream up a situation.
That's a good question.
Right.
Any cause of failing has to be either human or non-human, and if it's non-human, it's natural. Give us some type of failing, any type of failing that wouldn't fall into that exclusion.
If it's a pipe physical failure, I'm standing here right now, I can't think of one. I might be able to, but like you mentioned, if it is something like a contamination of the pipe where it doesn't
But you
fail,
said
but
that's
it's
human.
correct, but it's not a force. It's not a human force. That would be just over
But
time.
if it falls because of the problem, it was still gravity, wasn't it?
That's why I was saying if it's a physical failing of the pipe, standing here right now, I can't think of one because it would involve something.
Even under your construction, any and all causes, you can't tell me a single cause that wouldn't be excluded. This is just an exclusion for anything that happens to your pipes.
If it's a failure of the pipe, that's why it is
Yeah, if
That's
the
a
pipe fails
super hot
for
water damage
any
issue.
cause of any kind, no coverage.
that I can think of standing here. I mean, it's going to be a human force. Well, like I said, if it was,
If it kept, just give me yes or no. If it's a yes or
I can't-
no, don't
that
say,
is right, that
can
is
you
right.
give me any cause of any kind in the universe that we live in of pipe failure that would not be within this exclusion?
if a human put a contaminant down there that slowly ate through the pipe, that was not nature doing it, it was a human contaminant. And the pipe gravity didn't pull on it, it didn't fail that way, it was some sort of corrosive material that humans put down there and it ate through the pipe. I suppose that would qualify because it's not a human force that did it, but it was human negligence that made it happen.
All right, that's your time. Thank you.
And I can pick up right where council left off. The People's Trust has told trial courts across this state that this is a broad exclusion and encompasses any type of loss whatsoever to the pipes. It doesn't. It doesn't. We have the specific grant of coverage for wear and tear, and they needed to exclude that with specificity. The interpreting this exclusion narrowly, as we're required to do, it doesn't address these natural processes.
Council, one of the things you said is that, and I thought it was an interesting point, is that parts of this policy were just written at different times, and maybe people were more comfortable with non-secular language at certain points, and in later points in the drafting, they were more comfortable with secular language. And that maybe that explains the difference between the use of act of God and act of nature, even though they're separate terms. And I guess I wanted to ask a follow-up to that, which is how do we know what was in their head? In other words, one of the reasons we use canons of construction is because we can't know what's in their head, right? And I certainly see your point. It's certainly possible that somebody, in 1980 or whenever, these contracts started getting written, was more comfortable with the term act of God. And over time, people just became more comfortable with secular language. It's also possible people had a different meaning in mind, right, for the two phrases, because presumably whoever was writing the new sections of the contract, they certainly had access to the old sections of the contract, right? They could have gone back and corrected it if they didn't like act of God anymore. They could have gone back to make it all act of nature if they wanted them to be synonymous. But they clearly knew act of God was there and that they were using a different term. So how do we know that that actually explains it as opposed to they intended to have a different meaning?
We look at the context in which they're used, and they're used, act of nature and act of God here are used in similar ways in this. Their act of God is going to be something occurs in a moment of time, natural process in a long period of time. This act of nature, the way they've used it here, they're using it the same way as they would use act of God. But the fact that we have to figure that out, I think inures to our benefit when the exclusion has to be interpreted narrowly. The grant of coverage has to be interpreted broadly. And if they want to exclude this very important, unique, and valuable coverage that's valuable not only to us, but to them, they need to say so with specificity, and they knew how to do it. They could have just said, however caused, regardless of the cause, the way I've cited those multiple cases throughout the brief on how they could have done it broadly. They chose to put this term in there. Interpreting narrowly doesn't address these natural processes, especially when they know how to say it. As to your steel example, there's a specific grant of coverage in there. There's a grant of coverage for latent defect in this same section, this wear and tear, or any quality of property that damages or destroys itself. Those are not acts of God. They're materially different.
So I have kind of an unrelated question, and I would entreat you not to read anything too much into it, but it's just something that's wearing on me. If People's Trust prevails on its arguments on appeal, your client's still going to recover, albeit in a much lower amount. How do we analyze that vis-a-vis your fee request? And how do we analyze your fee request in light of the subsequent repeal of the statute on which it's based?
So right. If you reverse, then that's why we separated out water damage and tear out for that particular issue. And then my fee request to you is simply entitlement. And then we go to a fee hearing, and first thing I would do is see if they're inextricably intertwined. We have a fee hearing with the trial court, and I think we fight out that issue and determine what part of the fees are inextricably intertwined and what part are focused solely on act of nature versus issue 2.
And you would propose to effectively make the argument about the continued applicability or inapplicability of the fee statute as a matter of first instance at that point?
100%. And I have had multiple fee hearings that are, and we just look at Menendez, and they don't, in the statute, they did not say that the fee portion would be retroactive. And so it's the old law, and I litigated that issue, but frankly, I don't know that People's Trust has a different opinion on that particular issue itself.
All right. Well, I just wanted to ask you, thank you for your time and your patience. We'll let you go.
Thank you. Bye-bye, everybody.
All right. And you're excused. Second case on our, you guys want to keep going? Are you good? Yep. All right. Second case on our docket today, and we'll give the lawyers some time to come up and get set up, is 23-837 Old Florida Homes LLC versus Susan J. and Thomas Mazza. Counsel, we apologize for the late start. It was a circumstance out of our particular control. take your time getting set up. And Mr. Deere, whenever you're ready, just approach the podium and we'll get going. So I've got the standard is going to be the 5 minutes for rebuttal. Is that fine, or would you like more or less?
That's what I was going to ask for you.
Sounds good. All right, you may proceed.
Good morning, Your Honor. Michael Deere, first of all, may it please the court, Michael Deere for appellant, Old Florida Homes. This is a case on appeal. It's a non-final order addressing a lien claim only and a counterclaim for exaggerated or willfully exaggerated lien, fraudulent lien. There are two parts really to the appeal, and I want to address the first and then move on to the second. The first.
Can we talk jurisdiction for just a second
Sure.
first? Are you at peace with the fact that we're acting under our jurisdiction, or do you still want to make an argument for non-final?
No, I accept that.
Okay, go ahead.
The issue with the notary stamp, and I won't go too far into the facts because I understand you're certainly aware of the facts of the case. The lien filed by my client lacked a notary stamp. This is a third party, obviously a notary at a bank or wherever he obtained the notary certification from, but it includes the notary signature and includes all other necessary items under 713.08. And so I want to look first at the statute 713.08 and dive into whether or not the lack of the notary stamp itself is fatal to my client's lien. And if we look at 713.08, it provides a form claim of lien and says that under section 3, the claim of liens shall be sufficient if it's in substantially the following form that includes the following warning, and then it goes through the form claim of lien, which includes the jurat at the end. Following that, without changing the paragraph number, in the same paragraph 3 at the bottom, it says, however, the negligent inclusion or omission of any information in the claim of lien which has not prejudiced the owner does not constitute a default that operates to defeat an otherwise valid lien. And then in 4A goes on to say, the omission of any of the foregoing details or errors in such claim of lien shall not, within the discretion of the trial court, prevent the enforcement of such lien as against one who has not been adversely affected by such omission or error. And so the heart of our argument is that when the court entered summary judgment on the notary issue, the court did not undertake, and there in fact was no argument at the trial level by Ms. Maza that there was prejudice. There was no evidence, summary judgment evidence in support of that allegation, and it wasn't argued and it wasn't entertained by the trial court. And that's the error that I'm pointing to with regard to the notary stamp issue.
Counsel, let me ask you this. Would you agree that a construction lien must be notarized in a general sense?
I do agree that that requirement exists in the statute, and in fact, as I stated, there's a jurat specifically in the form.
And if the construction lien omits all notary information, includes no name, date, signature of a notary, it's simply signed by the lienor. Is it still a case that only if prejudice is shown by the property owner that can be deemed a defect with the lien, or is there some degree of I don't know, negligence or some degree of absence of notary information that makes prejudice to the property owner irrelevant, and it's just an invalid lien because it doesn't have enough on it?
I think there's two responses to that, Your Honor. I think first, that would fall under 4A, where the court in its discretion would analyze that issue, but also cited in the reply brief is a case, I believe it's pronounced Obi, it's a divorce case where an out-of-state notary, and it's decided by in the response brief, an out-of-state notary, I guess, was attempted to be used and didn't include that information that you stated, the notary signature or a stamp of any kind. The Florida court found that was inappropriate, but I think that's distinguishable here. I think to answer your question, I think directly, there would be a tougher hill to climb for my client if that were the case. But I think here we're talking about an otherwise valid lien with the notary signature. And so I think that distinguishes us from the response brief case, the OB. I think it's OB.
Where do you draw the line in terms of how off the notary stamp needs to be?
How off?
Well, because I think the hypothetical Judge Ganem gave was kind of a notary stamp missing everything.
Yeah.
Right, and yours is just missing one piece.
Right.
How much of it, right? Like, for instance, notary stamps gotta have the expiration date, like the expiration date of the notary's person, right? So there's several components to a notary stamp. How many can be missing before it's still accepted?
I think that's the discretionary issue, and I think the answer to that question, and even really to both questions, is that there must be discretion exercised, and there must be a finding of prejudice as to the specific omission. And so, to answer your question, there might be prejudice if, for instance, the claim of lien is not mailed within 15 days. There might be an issue where the owner is prejudiced because they didn't know there was a lien, they're trying to refinance or something. To answer your question, I don't think there's a scale where you get to a point where, okay, fine, there's just no discretion that can be exercised here.
You'd agree if the notary stamp was completely missing, right, that the lien would be invalid?
I think
Or even if there's no notary stamp, there still have to be prejudice?
there would still have to be prejudice. Well, if there's no notary stamp, I think we have a different issue altogether, because there is a notary stamp in the form, and it does say.
That's my point. How do you define no notary stamp, right? You have
Yeah.
several components to a notary stamp. How many of them have to be missing before we can say there wasn't an adequate notary stamp?
I think under that analysis or that hypothetical, we would be analyzing the case under section 3, which is the claim of lien shall be sufficient if it's substantially in the following form. And I think in that scenario, it would not be substantially in the form, because there would be no notary stamp attempted or.
And what I'm saying, assume one was attempted. There are various components. You got the stamp, you got the signature, you have the notary's license number, you have the expiration date, you have the date that it was actually notarized. You have the both signature as well as the printed name. Like, there's multiple pieces of a notary stamp, right? How many of them have to be missing before we say there was no notary stamp?
I don't think there's a case that, or anywhere in the statute that says that you can arrive at a decision that it's just too much, and there's some line in the sand where these missing items constitute a wholly invalid lien. I think the prejudice can be assessed or measured for each of those items. And there might be greater prejudice for more items being missing, but I think there still must be the finding of prejudice or that the owner had been negatively affected by the lack of inclusion of those items.
Bringing you back to our jurisdiction. If we're acting under cert jurisdiction, a departure from the essential requirements of the law, there's a number of cases that typically say, this isn't just basic legal error. This is something much higher than that. When you start talking to my colleagues about these lines and where we fit on this particular sliding scale, it just occurs to me that it might be harder to make the argument this is a departure of the essential requirements of law, from the essential requirements of law, as opposed to, I think what you're saying, which is it's going to depend on this line as to whether it's error at all. Does that make sense?
If I understand your question, I think
you're dealing with a higher standard, is my point.
I understand that, and I think the essential requirement of the law is that there be an analysis of prejudice to the owner. If there's no analysis whatsoever and there's no argument in the summary judgment motion by appellee, then that's the failure at the trial court level that requires the appellate court to take corrective action, because there's no. Back to Judge Mize's question, I don't think there's a scale, and I don't think you get to a point where you say, okay, there's too many missing things. I think each missing thing must be subject to the prejudice determination.
Counsel, on page 3 of your reply brief, you cite the case Pantry, the MIDAX manager.
Yeah, sure.
And you make a statement that Pantry modifies the notary law found at Florida Statute, Chapter 117. Did you mean that case, modifies the plain language and requirements of the notary law, or just that Pantry interprets the notary law?
I maybe could have written that more artfully. I think it interprets notary law, and that Pantry case and that issue, I think, was more of an issue at the summary judgment argument itself rather than on appeal. But the issue with Pantry in 117, Chapter 117 is the notary statute, is the strict compliance issues in 713, where 713 requires strict compliance. Citation to Pantry and analysis of 117, our argument is that you're outside of 713, you're looking at 117 in the pantry case and others. And you're analyzing that based on that case law, and the exception in pantry is the whole of an instrument may be resorted to for support of the acknowledgement. Wherever substance is found, obvious clerical errors and all technical omissions will be disregarded. And of course, that deals only with notarization rather than claim of lien. It doesn't contemplate claim three.
You're in the same brief, you suggest that because the requirement to apply the stamp is the notary's responsibility. It seems to you that you're suggesting that that excuses the lienor from basically checking behind the notary to making sure that all is in order before the claim of lien gets filed. Is there no responsibility on the part of the lienor to make sure all of the requirements are there? Can the lienor really just say, well, the notary didn't do it right, that's not my fault, my lien should still be valid?
I think academically, there are instances where a third party commits some malpractice that affects the rights of the litigation party. And I think to answer your question, I want to try to answer it directly. That would still fall on my client. That error is not, cannot say this is someone else's. It's not like a fabric defense where I can say this is someone else's error and we're wholly excused. But I think I made that argument to demonstrate this was a third party relied on by my client. So as the courts analyze it, whether or not there's prejudice, it wasn't willful by my client. It wasn't, negligence. He's testified, and there's some briefing that he did not obtain counsel's advice in filing that claim of lien. And so to that extent, he's unsophisticated with regard to filing a claim of lien. But yeah, I think that we would still have that issue, but then I go back to the whether the owner was affected or prejudiced by the lack of lien. So let me go back and just touch on some of these cases. I think we've talked quite a bit about showing a prejudice or deficiency, but again, just want to highlight that there was no, at summary judgment, there was no argument for the prejudice to the owner, and the court did not conduct that analysis and did not find in its rulings as to that analysis. So moving on to the second portion of Your Honor, my at 7 minutes, 45 seconds with 5 for rebuttal. So 2 minutes remaining.
Yes, sir.
Okay, let me move quickly through then the second portion, which is whether or not the lien was willfully exaggerated. For this, although I know you're probably more aware of the summary judgment standard than any others, I want to just touch on the standard just for a second. And this is from the Fitzpatrick versus City of Atlanta case. This is a case stemming from Celotex. And the moving party must show that on the all essential elements of its case on which it bears the burden of proof at trial, no reasonable jury could find for the non-moving party. If the movement failed to discharge the initial burden, then the motion must be denied. And that case goes on to talk about, even in the absence of a summary judgment response, the motion would be denied in that scenario where the movement fails to meet its burden. There's two issues that I think are glaring here. First, one case or one issue which is complained of by appellee that there was an exaggerated subcontractor invoice. Is addressed in the response brief, and it's even included in the summary judgment order, this Schaefer drywall invoice. And so I want to make it abundantly clear to the court, it's in the appellate record, that invoice was not in the record until supplemented after our initial brief had been filed. And so it would have been improper for the court to rely on that in ruling. The same is true at the initial summary judgment hearing with regard to the deposition of Melissa Coffey. Moving on to that issue, Melissa Coffey and Coffey Tile and Stone, there was an affidavit presented, which was her deposition testimony in an affidavit indicating that Old Florida Homes lien was improper because I didn't bill him those amounts, or he knew that those amounts were not due. She also testifies, though, that when she made the billing, when she forwarded the billing statements, they were due and payable at that time by Florida Homes. My client did, in summary judgment, provide a response specifically refuting those allegations and providing the backup upon which Old Florida Homes relied in compiling its lien as to Melissa Coffey and Coffee Towel and Stone. And those items add up to exactly what my client included in its sworn statement of account, which is the, I believe, $45,000 and some change. And so I'm going to go quickly here because I've got about 3 seconds left on my time before rebuttal.
You can use your time however you want to.
I would like to reserve some.
Okay.
I think of the issues complained of, in addition to the Coffee Towel and Stone and Schaefer Drywall invoices, which, as I've discussed, we've addressed Coffee Towel and Stone. Schaefer Drywall was not in the record. There is this argument that my client cannot charge for self-performed work and that the charge for self-performed work is improper and exaggeration of the lien. We cite a case, Gator Boring is the one that comes to mind initially, that essentially in that case, a drilling company was drilling through what it believed would be sand on a public project. When it reached, the sand became gravel or if it became granite, it could not bore through at the same price that it quoted. And so it had extra work for the change in circumstances that it wanted to bill to the owner, which was a municipality. And so the court found that that was a legitimate dispute as to the amount of work performed or amount needed to complete the contract. Similarly here, the 15% markup is a contractor fee. That's an oversight fee for contractor's duties. It is not for any, it does not contemplate any self-performed work in the contract. It doesn't say that you shall receive 15% and you shall also do these other things. And so when a contractor undertakes to do self-performed work, my argument and my assertion is that self-performed work could be and likely is a savings to the owner. And so that's a fact issue for the jury to determine whether my client acted negligently or exaggerated the lien by doing self-performed work and charging for it. That work done by the contractor may have been done by a subcontractor, or he may have found a subcontractor bids were too high and he thought he could do it cheaper at, I think it was a $20,000 charge for certain work at a savings to the owner, but that would be a fact issue for the jury. And so I don't think on the evidence in the record, there's a clear exaggeration of the lien based solely on that issue. Again, case we cite as Sam Rogers. I'm going to stop in just a second and move on to reserve for rebuttal, but Sam Rogers, Crops versus Chimera. And this is a contract dispute over $10,000 difference in two contracts. And this is a case where there were items exaggerated by the contractor due to the contractor having to hold the property it was constructing for the owner's benefit. Some of those items were, I believe, taxes and insurance, as well as some weatherproofing of the house during storms. And so the court found that that's really just a fact issue and that might be an error or good faith dispute as to the amount due. So I would submit that those are the issues on the willfulness of the exaggerated lien. And then finally, before I yield, profit and overhead, Haney Chevrolet, we cited that case. That can be included in a lien when it is part of the contract. Generally, there are items that cannot be included in a lien, but when included in the contract, which it was here, 15% markup is consistently billed and applied to the billing statements and included in the initial contract. It becomes lienable and Haney stands for that proposition. So I've got a minute and a half left. I'll reserve.
Thank you.
Thank you, Your Honor.
Good morning, may it please the court. Robert Weil from Gray Robinson on behalf of Tom and Susan Mazza, the homeowner in this case. I guess the best place to start is jurisdiction. We believe that jurisdiction is proper under common law certiorari. 4 of the DCAs have come to that conclusion. The only holdout is the 3rd DCA, and they found that it's akin to injunction, which we disagree with. We don't think it's in the nature of injunctive relief because there's no judicial action involved.
You're reading that case law commensurately with the case law involving lis pendens.
Say it again.
You're reading that case law and that split commensurately with the case law on list pendants?
Yes, Your Honor, exactly right. It's created without judicial action, list pendants, and also the list pendants does not mandate or prohibit any type of action. Merely provides notice of pending litigation. So that's why we don't believe it's a non-final order relating to an injunction.
We issued a decision a few weeks ago involving list pendants where we said that we were not going to exercise our certiorari jurisdiction over a situation in which a trial court had declined to discharge a list pendants. I mean, obviously, there's a way to distinguish your case from that one. But I wondered if you'd seen that and if you had any thoughts on how, if at all, it affects our jurisdiction here.
I haven't seen the case, but I think that may go to the irreparable harm aspect. And because the list pendants remained in effect and the liener was still entitled to his security at the end of the case, there would be no irreparable harm and probably no certiorari jurisdiction in that case. Because certiorari jurisdiction applies here, we believe that the petition has an extremely high burden to overcome, as Judge Traver, you observed. He doesn't have to prove just error. He has to prove something far beyond legal error. That's from the Haines City Supreme Court of Florida case. And then also they must establish a violation of a clearly established principle of law resulting in a miscarriage of justice. So our position is that here is there's no error, but even if there was error, they have not been able to meet the burden for certiorari review in this case. And I also like to highlight for the court that certiorari review is discretionary. Even if they are able to prove a departure from the essential requirements of law, this court still has discretion not to grant the writ if they so decide, if you so decide. Turning to the first issue, the notary stamp issue, our position is that because the claim of lien did not have the notary seal, it did not strictly comply with the lien law. The lien law must be strictly construed because it is in derogation of the common law and it's a creature of statute. There's also a specific statute in the lien law which says that it is not to be liberally construed. We also cite a couple of cases in our brief dealing with affidavits, and those cases involve affidavits that were missing an actual seal. And in both those cases, the courts found that the affidavit had no force or effect because it lacked the seal. They just did not operate as a legal document because they lacked the seal. And our belief is that the importance of the seal is not a trivial matter. It goes to the heart of the enforceability of the legal document, and it's also a safeguard. The seal is there to announce to the public that someone who is authorized as a notary, stamped and certified that the person who is signing the document is actually the person who is before the notary, and it prevents false notaries from basically just signing a document without the stamp. Only notaries are sent the stamp when they apply to become a notary.
Counsel, let me ask you a similar question to what we asked your colleague. Can any part of the notary, either the jurat or the stamp, can anything be missing and trigger the requirement that prejudice be shown by the property owner, or if any part of that notary area is missing, is it just automatically an invalid lien?
So some of the cases talk about the certificate of acknowledgement, and that's the section where the actual notary certifies that the person before them is who they are and what they provided for identification. And there's some cases which seem to indicate that that will be enforced when possible. And there's sort of a trivial or a minor mistake in that section will still be upheld as long as it's not prejudicial.
So you're saying if the difference is that instead of saying the foregoing person, swore or affirmed that this is true, instead they say the foregoing person acknowledged this document, some kind of difference in language.
That's exactly right. And there's actually a case that was cited that deals with that exact issue.
Is there a way to read that case as holding faithfully in connection with how the lien statute is written? Or is that case law an expansion of the lien statute?
So that's the pantry case. So that in that case, there was language where the court said, wherever substance is found in an instrument, obvious clerical errors, and all technical omissions will be disregarded. That case involved a restrictive covenant and whether it provided notice to a subsequent purchaser. And the court found that a minor alteration in the language, in other words, the words sworn to were used instead of acknowledged. And that minor alteration did not somehow invalidate the restrictive covenant because it still provided notice. And there are actually statutes in that case, 2 statutes that preserve constructive notice imparted by documents that do not strictly comply with the technical notarial requirements. Unfortunately, in our case, there's no statute like that in the lien law. So that's one reason why that case is distinguishable and can't be applied to our facts. And also, the issue here is not notice. The issue here is whether the lien validly secured the purported debt. I think the lack of the seal goes to the heart of the enforceability of the claim of lien itself. So our position also is that the notary seal is not information, and that therefore we did not have to show prejudice in order to nullify the lien. And our position is based upon a couple of arguments. First of all, in subsection 1 of the lien statute, claim of lien statute, it actually enumerates 8 pieces of information. Subsection 2 is where the notary requirement is located. Our position is that the use of information in the lien statute refers to those 8 pieces of information. And this construction is actually confirmed by another statute in the lien laws. So there's section 713.16. That statute allows a homeowner to request from a liener a sworn statement of account. And the sworn statement of account must contain certain information. And that information is very similar to a claim of lien. There's a substantial overlap in the information. And the actual sworn statement statute, 713.6, contains almost exact same language as the claim of lien law. It says, the negligent inclusion or omission of any information deprives the person of his or her lien to the extent the owner can demonstrate prejudice from such act or omission by the liener. And the subsection 7 of the statute, 713.16, actually defines information. And it says as follows: the term information means the nature and quantity of the labor, services, and materials furnished or to be furnished by a liener, and the amount paid, the amount due, and the amount to become due on the liener's account. There's no mention of seal, there's no mention of oath in there. So our position is that the entire lien law, chapter 713, must be read as a whole. And because one of the statutes actually defines information, that interpretation must be grafted on the actual claim of lien statute as well. We don't believe that 713.084A changes the analysis at all. So that statute uses a slightly different language and says the omission of any of the foregoing details. But that language appears just below the other language beneath the claim of lien form, which talks about the omission of information. And I think the omission of information and foregoing details are synonymous with one another. That's the only reasonable way to interpret the statute. So the reply brief cites a couple of cases that at first blush may seem to support the notion that we had to show prejudice. The first case is the Florida Wood Services case. In that case, the owner requested from the liener a statement of accounts pursuant to 713.16, and the trial court found that the lien was invalid because it was not administered, the liener was not administered an oath by the notary. The district court found that the trial court should have determined whether the owner was prejudiced. But in 1999, the year after that decision came out, the legislature amended 713.16 to actually define information, as I mentioned a few minutes ago. And also, it appeared to directly address the Florida Wood Services case and said as follows: the failure to furnish the statement under oath does not constitute an omission of information and shall deprive the liener of his or her lien. So at one point in time, 713.16 stated that the omission of an oath is not information, slightly different from a notary seal, but in the same ballpark, and that it would invalidate the liener's lien. Another case that they cited in the reply brief is the Stunkel case. That involved a claim of lien where the liener was not administered an oath. And the Florida Supreme Court, relying on 713.084A, held that the trial court should have determined whether the lien adversely affected the owners. But that case also was followed up by 2 statutory amendments to the lien law. In 2003, the legislature added after the claim of lien form the following language. However, the negligent inclusion or omission of any information in the claim of lien, which has not prejudiced the owner, does not constitute default that operates to defeat an otherwise valid lien. And as I mentioned before, 1999, the legislature also amended 713.16 by adding subsection 7, which defines information. I'm going to move now on to the fraudulent lien issue. Under the statute, if the lien is found to be fraudulent, it's a complete defense of the enforcement of the lien. A fraudulent lien is defined as a willful exaggeration of a lien amount, or willful inclusion of work not performed, or materials not furnished, or compiled with gross negligence. I think in our case, we're falling under the willful exaggeration part and compiled with gross negligence. In order to establish willfulness under Florida law, it can be proven by 3 ways. It can be by actual knowledge of the falsity, it could be without knowledge of the truth or falsity, or it could be a situation where the liener should have known of the falsity. And I think all 3 of those apply to our facts in this situation. In our case, we don't have just one category of amount that was deemed fraudulent by the trial court. We have 5. The first is non-lienable items. You can only include in a lien an item that adds value to the property and that's a permanent benefit to the property. Our position is that an oversight fee and management fees are not an improvement to the property and should not have been included in the lien.
Would you agree that those amounts are lienable if it's provided in the contract between the lienor and the property owner that, the contract price includes this 15% markup for oversight and management and things like that?
Our position said it's not overhead or profit, but if the court determined it to be overhead or profit, you are correct that if the oversight fees were rolled into a fixed cost contract and the cost of the materials furnished or the services provided, then yes, it would probably be considered a lienable item. But we don't have that here.
In what scenario would a fee to the contractor not be profit?
Well, in this situation, the fee was for oversight and management of other subcontractors on the job.
Yeah,
So
so
they
they provide
provide-
profit on that fee. Like if I charge you to oversee somebody else's work, isn't the fee I charge you my profit?
Not necessarily, because I think in this case, a service is being provided. He's overseeing the management of the job, and therefore it's not profit. It's a service being provided. He's being paid for the service.
Counsel, and there's many cases where the general contractor's license allows that contractor to do more things than perhaps some of the subcontractors involved on a project. Doesn't that oversight provided by the general contractor provide value to the property by making sure the subcontractors do their work correctly?
I don't agree with that. I don't think oversight is an improvement to the property at all. It's not labor furnished to.
Yeah, but it's making sure somebody doesn't screw up the labor, right? Like part of installing a sink is making sure it's not screwed up, right?
True, but I still don't believe it's actually an improvement to the property. I don't see that as something adding value to the
The
property.
sink doesn't add value.
No, but the sink may add value, but the supervision of the installation of the sink does not add value.
Well, I mean, how do you draw that line, right? So if you have one worker who doesn't know what he's doing, but he's cheap, and you hire a better worker who does know what he's doing and he costs more, that adds value, right? Because you're paying the worker to install the sink,
Yes, sir.
making sure it's done correctly. All right, well, you determined the best way to make sure it's done correctly is to have a second set of eyes, right? Making sure the person doesn't screw it up, making sure it's installed correctly. How's that any different? Like it's a judgment call as to what's necessary to install a sink, isn't it?
Yes,
Okay. So if somebody decides in order to do this sink correctly, because for whatever reason, I need a second set of eyes, you tell me that doesn't part and parcel to installing the sink?
I think it's part and parcel, but I don't think it adds value to the property. I don't think it's an improvement to the land. I don't. It's
It
separate and
didn't have a
distinct.
sink before, now it has a sink. And that an improvement?
Yeah, but the sink would have been there regardless of whether there was supervision or not.
Not if you think the supervision is necessary to install it correctly.
That. I don't think.
I mean, isn't that the reason companies to perform all types of services have supervisors, or does the entire concept of a supervisor and construction useless and adds no value?
Yes,
When you supervise associates,
yes,
do you add value?
yes,
Why?
because a lot of times I improve the final work product.
Okay, well, why doesn't that apply to construction?
Because in construction, the laws are different and the laws have to be strictly construed. And there's been no citation of a single case by the petitioner here holding that oversight and management constitutes a lienable item. And even if it's considered overhead or profit, it was not, it was a separate line item in the change orders and therefore did not constitute a lienable item. And that's what the case law says.
Let me ask you about that aspect of it, because I think, doesn't the law also allow outside of a contract, if overhead and profit are sort of incorporated into what's considered a reasonable price for the work performed or for the improvement that's provided? Suppose you have a contractor who bills the property owner a line item for the actual cost of materials and then a line item for overhead and profit. But put together, they constitute a reasonable price for those items. Is that all lienable, or if it's separated out into different line items, does that just make the overhead and profit not lienable?
I think it makes overhead and profit not lienable under the case law. And I think that's the Haney case and the Surf Properties case that we cite in the briefs. Moving on to the second category, the general contractor here also applied oversight fees to self-perform work and supervisor fees. So it was almost double billing for supervision here. He was charging basically oversight for his own work and oversight for his own supervisor who was on the job. There were also duplicate charges, and during his deposition, the principal of Old Florida Homes actually conceded that there was a duplication of charges. Old Florida Home contends that this was de minimis. While this single item may be de minimis when taken together with the other four items, which total over almost $140,000, I don't think the amounts that were included in the lien that are fraudulent can be considered de minimis. With respect to the Schaefer drywall, Old Florida Homes mentioned that the Schaefer affidavit was not in the summary judgment record, but not only was that waived because it wasn't raised below, but we moved to supplement the Schaefer affidavit to the record on appeal because it was before the trial court at the time the court made its decision. In fact, the Schaefer affidavit is referenced in the court's decision, and this court granted supplementation to put it in the record because it was considered by the trial court. So not only was there a waiver, but it was considered by the trial court, so it was properly in the summary judgment record. Lastly, I want to mention that Old Florida Home relies on their affidavit to try to establish a disputed issue of material fact. But the statements in the affidavit are conclusory. He says that we relied in good faith on information provided by subcontractors and the status of the account, and says that we didn't intend to exaggerate. But the case law requires more than just these conclusory statements. There has to be an explanation. Mr. Sexton did not explain during his deposition or in his affidavit as to how he complied with this good faith requirement and how he had no intent to exaggerate. In fact, one of the most important factors that courts consider in determining whether a lien is fraudulent is whether the liener consulted with counsel before filing the claim of lien. In this case, Mr. Sexton was asked during his deposition whether he consulted with counsel, and he said yes. And the next question was, well, did you consult with him before?
If you could wrap up.
Sure. So for the foregoing reasons, we ask this court affirm the partial summary judgment entered by the trial court on the fraudulent lien counterclaim and on the lien foreclosure claim. Thank you.
Thank you, Mr. Wong. Mr. Deere, you have about 90 seconds left.
Certainly does move fast on this side. I want to address just a couple things. We did cite Haney case as to the overhead and profit. And I think, Your Honor, you were correct in asking where else is the profit? The facts of this case are that this is a cost plus contract for construction. There are several types of construction contracts we don't have time to go into.
I don't
They
think
are-
your argument is strong though as to the supervisor fees on their own work.
I think the supervisor fee is a subcontractor. I think that's a fact issue. It's a subcontractor on site that was hired to be on site. And so the markup, as they're arguing, I think is lienable under Haney. I think that issue is lienable. I think that work is lienable because it's included in the contract price. I would argue. I understand that argument, but I think that is lienable, and I think that it is under Haney appropriate. I think we don't agree on some of the facts. I don't agree if there's an exaggeration of $140,000. I think that's in the record in our briefs. There is one duplicate charge that my client admitted readily at deposition for $456. This is a $2 million construction project. So in the context, even if $20,000 were on the bill, it would be still 1% of the total contract price. And so I think that must be considered. And then finally, a reduction in the contract, or I'm sorry, a reduction in the lien amount by the trial court does not amount per se to a willful or exaggerated lien. It can be simply an error, can be reduced by the trial court, and that does not render the lien ineffective. Thank you.
Thank you, Mr. Deere. Appreciate the arguments and submissions of both parties, and we'll take the matter under advisement. You want to keep going? Can you break? We're going to take a 5-minute recess. We'll be right back. All right. Thank you. Court's back in session. Before we start and I reintroduce the panel, let me also extend my apologies for our court being late this morning as it relates to hearing this particular case. Counsel was here on time. You guys understand that it was outside of our particular control. But that said, to you folks who worked hard and have other matters to deal with, we're sorry. To those folks who are here who were expecting to see something 20 minutes before it started, I'm sorry. I'm Judge Dan Traver. To my right is the Honorable Joshua Mize. To my left is the Honorable Roger Ganem. This is the last case of our afternoon, 23-1461, Alonzo Smith versus the state of Florida. Mr. Pinnell, are you arguing today?
Yeah.
All right. How much time would you like for rebuttal?
5 minutes. Please.
Excellent. At your pleasure.
May it please the court, my name is William Pinnell and I represent Alonzo Smith. As noted in our briefs, the trial court committed 4 separate errors.
I think this is going to be one of those arguments where I barely let you get out your name.
Yeah, I had the same
All
thought.
right, sounds good.
So let me start you with just a foundational matter on your first issue, which is the firearm.
Sure.
Do you view a difference between the Supreme Court's statement in Jackson as to what our appropriate test here is in terms of a sufficient link as being qualitatively different than the relevant statute 401? And if so, what's that difference?
Could you ask the question again? I'm not-
Yeah, no
I'm
problem.
sorry.
So let me actually walk you through it. So
Sure.
401 talks about relevant evidence is evidence tending to prove or disprove a material fact.
Sure.
That's all first day of evidence in law school.
Right.
When we look at Amorose, which is the first time that we start seeing the Florida Supreme Court chiming in on the necessary link, if any, between a firearm that clearly isn't used in the context of the crime that's alleged versus its relevance to come into that case anyway. Amorose starts talking about 401. It grounds its analysis in 401. You fast forward to 2009 in Jackson, it applies Amorose, but it says the state must show a sufficient link between the weapon and the crime. Jackson doesn't mention the relevant statutes at all, even though they probably should have.
Okay.
Then it goes to Agathias. I think I'm pronouncing that correctly. Now the Agathias court 2 years after that is saying, hey, we've held there needs to be a sufficient link. Now, you didn't hold any such thing 2 years ago. You basically cobbled something together from that initial case. So winding you all the way back to it, on one hand, we have 401, which is the statute passed by the legislature, which says prove or disprove a material fact. And on the other hand, we have Jackson and maybe Agathias that talk about a sufficient link. Do I read those the same or differently?
I think they're the same. I think they're just all a way of saying relevant and which is relevant to a material fact or necessary to prove a relevant fact. And it's our position that both the 5.7 handgun found in Mr. Smith's vehicle and the photos of the ammunition found at his home are not relevant and not related to the crime in this case and should not have been admissible. To the extent there's some minor relevance, it's outweighed by the danger of unfair prejudice because it's evidence of bad character or propensity to commit the alleged crimes, which Agathias talks about as being an axiomatic error that's committed when you allow that evidencing. Now, certainly there's cases where a firearm not used in the or not connected to the charged offense could be admissible in the state points to the Owens case, but that's much different where they use that firearm to get access to the murder weapon and dispose of it. So it's kind of
so it seems like we're walking through 3 separate steps here.
Sure.
If you agree that they're the same. And I frankly don't know how you tell the difference between a sufficient link and 401. But you've got the 401 issue of is it relevant or not? And then you've got the 403 issue, which it's relevant, but it's substantially prejudicial.
Sure.
And then you've got the harmless error analysis. Are we seeing this the same way?
I am. We are.
Okay.
So it's our position here that the general rule is that a gun different than the one used in the crime is not relevant to prove that the crime occurred. And that comes from a variety of cases, including the Jean Bear case from the 4th DCA in 2020. And it's our position, our case, that's the case that's most analogous to our facts of our case. And interestingly, the state failed to address that case on in its answer brief, it's our position, it's because they cannot distinguish it from the facts of our case. In that case, there's two individuals in a vehicle, and the defendant, and there's a shooting from that vehicle to another vehicle, and there's a search of the vehicle after the shooting, and two different firearms are discovered. One is a Ruger 45 that the co-defendant used.
We're all familiar with John Bird.
Okay.
Yeah, so it's interesting in John Bird, just an observation that it sounded like, at least from the tenor of the opinion, it looked like the state wanted to introduce the non-related firearm that was found outside the passenger door after a subsequent accident to show that Mr. John Bird was the driver. If I change the state's proffered reasoning slightly, does John Bird change? What if the state had said, I'm only introducing this unrelated firearm that was found shortly after a couple of car chases, albeit when Mr. John Bird was no longer in the car because he fled it after the first car chase, to show that just he was in the car? Does it become relevant at that point?
Well, they say it's not relevant because, or at least not relevant enough to overcome the 403 analysis, because there's testimony from the driver of the other vehicle and the officer identifying the defendant as the driver. So it's not necessary.
So I think if you're answering my question correctly, I'd lose you not on the first step, but on the second step. So in other words, yes, Judge, in that particular instance, it would be relevant to show that, yes, he was in the car at some point. But I lose you on substantial prejudice because there were a whole lot of other ways to
Correct. And in our case, the state argues that they need to show that the firearm found in the 5.7 handgun found in the glove compartment was connected to Mr. Smith, and he had dominion and control over it. Because to show that he also had dominion and control over the 20 caliber or the 40 caliber magazine, a 45 caliber magazine found in the glove compartment. And it's our position, like in Gene Bird, they don't need that because they have evidence that it's his vehicle and parked outside his home, and he never disputes that's his vehicle. So they already have evidence to show that.
But it seems like that's a little different. So I understand your argument on John Bird to be just the fact that it's a gun when you had all of this other stuff makes it unfairly prejudicial. It seems like what you just said, though, gets more to another prong of 403, which is that it's unnecessarily cumulative. So in other words, you have so much already, state, that you're just piling on at this particular point. And if I think about Mr. Smith's case, I don't think about a situation. Clearly, it's outlined in your brief. It's a circumstantial evidence case where the state was overflowing with confessions or DNA evidence or eyewitness high-def video. So I don't necessarily know if your analysis tracks between those two things.
Well, I think in John Bear, and my French is not very good, so I apologize. So in John Bear, they say that they point out the fact that because they could identify the officer and the victim identified the defendant, that they didn't need to introduce the gun. So, and they use that for their 403 analysis. So it's both prejudicial and cumulative. So I think that's how it tracks. They're saying they don't need that. And now you're prejudicing the jury and showing that this is a guy that possesses a lot of guns and a lot of weapons. And then there's no basis to introduce the firearm evidence or ammunition evidence in exhibit 31, which is just ammunition that does not match the murder weapon.
What is it about the nature of a gun itself that's unfairly prejudicial? In other words, couldn't a reasonable juror basically think that your client was just like any of the other hundreds of millions of lawful gun owners in this country?
They could, but now you have a gun, and now you have ammunition at a house, you have a gun in a car, and it starts to reach into the point where the state is suggesting this is a person who has an arsenal and appeals to the jury that, you know, because he has an arsenal of weapons and fire and ammunition, he's dangerous. And that's what Gardner from the Fifth and Agathias from the Florida Supreme Court says, is that this evidence is evidence of bad character or propensity to commit the alleged crime. So I think it's well established that unrelated gun evidence is prejudicial and should not be admitted unless it's relevant, unless the relevance is not outweighed by the danger of unfair prejudice.
Can I take you back to the amount of relevance it has, counsel? Because I see this, the point the state made that the 5.7 was useful to show connection to the magazine, but that implies the magazine had a connection to the murder weapon, right? And I saw everybody referring to the murder weapon as a Glock 40. I never saw where that was established by any actual evidence. It just seemed like everybody said it. And so what did I miss? Because obviously the bullets taken, that were found were 40 caliber bullets and casings, but that just tells you it's a 40 caliber. It doesn't tell you it's a 40 caliber Glock, right? And the reason I bring that up is, and I don't even know if it was, maybe it was waived because everybody just said it was a Glock 40. Nobody seemed to dispute it. So if I just missed something, feel free to cut me off. The reason I bring that up is I think it goes to if you're talking about the importance of the connection between the 5.7 and the magazine, how relevant is the magazine? And here's what I mean by that. If all you know is that the murder weapon is a 40 caliber gun and he's got a 40 caliber magazine, there are dozens upon dozens upon dozens of 40 caliber guns currently on sale. And if you talk about all that have been on sale in the last 50 years, dozens and dozens and dozens more. If you talk about specifically the Glock 40, that's a much tighter connection between that magazine and the murder weapon.
Sure.
And that to me is not a small distinction. So where was it established that the murder weapon was a Glock 40 as opposed to just a 40 caliber handgun of some sort? I saw people just say it. I didn't see any actual evidence.
I don't have that in front of me. I certainly could provide that to the court at a later date, but I don't have that in front of me. I believe there was evidence of that, but
it seemed like defense counsel stated, obviously you stated it in your brief, and I looked because I was like, where am I missing this guy from somewhere? I searched the record. I can't find anywhere. And if they didn't recover the gun, I can't imagine how you would possibly figure that out, because unless you have something to match it to, which they didn't, there's no way looking from a 40 caliber round, either the casing or the bullet itself, to know what kind of gun it came from. It's not like there's anything imprinted on the bullet.
well, you're certainly correct that they did not recover the gun. So based on your observation, I would suggest that makes the evidence even less relevant to the.
But has that been waived? I mean, because defense counsel seemed to almost stipulate at trial that it was a 40 caliber Glock that killed the guy. And I mean, he ceded an argument. He said in closing, yes, the murder weapon was a Glock, but, and then he made his arguments. So can I, if I thought that was a meaningful distinction, can I do anything with it now?
I think you can. I think you can still look at the record and find, I mean, he certainly objected on relevance and over again at the trial and at the motion for new trial. So I think you can put that into the totality of the circumstances to determine relevance.
People can stipulate the facts, can't they?
Yeah, but I don't know. There's no stipulation that was read to the jury.
Do you think he was stipulating the facts or just basically accepting that the state had the ability based on the constellation of the evidence to prove that, to argue that inference?
I don't know what he was doing, but I certainly know it wasn't a stipulation as
Well, I mean,
we legally understand it.
In the appellate briefing, we're talking about the murder weapon being a Glock 40. Is that just accepting the reasonable inference that a juror could clearly make that this was potentially the murder weapon?
Potentially, yeah.
And I mean, that's a loaded adverb, obviously, for the question, for the reasons that my colleague was specifically asking about it, but.
I was just going to say, I mean, imagine the different scenarios, right? So you had, say it was a 9mm, right? The most popular handgun caliber, the most popular caliber in the United States, and there's hundreds of 9mm. Okay. Now, see on the other spectrum, it was like a 45 gap or an M1 Grand, a really rare round that doesn't shoot out of very many guns.
Sure.
If this was a 45 gap magazine, and we knew that the murder weapon was a 45 gap, which by the way can only be fired out of Glocks, right? Like that would be a really tight connection. As we're just any 9mm magazine to the universe of 9mm would be a hugely broad connection. And a 40 caliber kind of falls somewhere in the middle of those. A 40 caliber Glock is a much tighter connection than a 40 caliber gun.
Sure. So again, I think based on the court's observation and the relevance is weakened by the court's observation.
I want to stay with the probative value of the gun for a moment. Given the the sort of ubiquitous nature apparently of 40 caliber pistols, whether they're Glocks or otherwise, doesn't that add to the state's argument that using or getting in evidence of the 5.7 was necessary? And I'm talking about continuity here. You have evidence at the house of 40 caliber ammunition and a 40 caliber empty gun box. And you also have evidence at the home of 5.7 ammunition and an empty 5.7 gun box. And then you look at the compartment in the glove box that has 40 caliber ammunition and 5.7 ammunition, also a 5.7 pistol, but a missing 40 caliber pistol. Isn't that very probative of the fact that that's the compartment where this defendant used to store his guns, and there's a missing 40 caliber, which we also know was the caliber of the murder weapon.
I don't know, I guess I don't follow. I don't know that we know this is where the defendant stores his guns, because there's also guns located in his home.
Well, there's
I
a
mean-
gun in there with his DNA on it.
Sure.
Isn't it a fair inference that this is where he keeps his guns? And there's just a 40 caliber magazine, but no gun there. Where's that gun? And the murder weapon is a 40 caliber. I mean, isn't it at least probative of that fact enough to outweigh any sort of amorphous prejudice that may come from knowing that he owns more than one gun?
I disagree. I don't see how having the 5.7 gun prove or has any relevance to proving that there might have been a Glock. I don't see the line. I don't see it. And if there's some minor line, the unfair prejudice from all the combination of the firearm in the glove box and then all the ammunition in exhibit 31 makes it clear that there's prejudice. I mean, we have
like the point that Judge Ganem might be trying to make, and he'll correct me if I'm wrong, is that secret compartment that was in the back of the glove box, perhaps a reasonable juror could infer that that's just where the murder weapon was kept, because it was along with a clip that theoretically could have fit the murder weapon. I don't think that there was any evidence that it did. And then a 5.7 next to it with his DNA on it. I think that's the contention.
So our position would be, now we're speculating that with no evidence that the Glock was there. And even if it has the minor relevance, it's strong that way by the danger of unfair prejudice noted in the John Bear case, where you have two firearms found at the scene, and they still say one should be excluded from evidence. So
I think you've done an excellent job in your briefing of recognizing that there's a challenging standard on appeal. And I want to focus you on that abuse of discretion standard, especially as it relates to substantial prejudice. And it kind of harkens back to my question about the hundreds of millions of legal gun owners in America. Imagine for me that a hypothetical case, not this one, where what had his DNA on it next to the clip was a Nazi armband or child pornography or something that is either so inflammatory in today's culture or just outright illegal. Does that analysis change? It gets harder for the trial judge in that instance, doesn't it? And it gets easier for us to say it's an abuse of discretion.
It does, but I also think when we're talking about a murder case, when someone was shot with a gun, that another gun is the most prejudicial information you can get. So I agree.
Is it more than child pornography?
Well,
I mean, because what you're worried about is a propensity verdict.
sure.
You're worried about the fact that this is a gun crime and this is a gun. But when you make a propensity argument, propensity is kind of grounded in the idea that we don't want juries convicting somebody just because they think they're a bad person for other reasons. And that's where I kind of struggle with the guns analogy, because again, there are hundreds of millions of people walking around right now that are perfectly good people who have guns. I would draw a sharp distinction between that and the other two examples.
Sure, and I think on its own, you'd be right. I think in this particular case, when we're talking about shooting, I disagree. But I think the important part here is where the prejudice is exacerbated is what the prosecutor says in closing. So he says, the person that has a secret compartment in his vehicle that houses a gun and a magazine for a murder weapon is very likely the murderer.
Oh, he made a straight out propensity argument. And it was
right, and that's
made a straight out
1048
propensity argument. And that's what you worry about.
It doesn't really matter if being a gun owner actually gives you a bad propensity. It matters whether a jury might improperly infer that, right?
Well, they don't have to-
here and know there's nothing wrong with being a legal gun owner. which there's not, that doesn't mean there might not be members of the population on the jury who nonetheless have that feeling.
Right, and we
Because
don't have
it's
to
a
infer
divisive
that,
issue.
the prosecutor told them that, you know, because he possesses this other gun, he's likely guilty of the murder. So, and that's in rebuttal, that's the last person they hear from before they deliberate. I'll say the rest of my time for rebuttal.
I got one more question.
All right,
I do too, actually.
Go ahead.
I defer to the chief.
Based on what you said, though, about it being a gun case and the gun having an outsized significance, say we can't go down this, say we disagree with you and we decide that it's relevant for the sake of this hypothetical. And then we get to unfair prejudice. Is what you said an invitation to write an opinion that says that in a gun case, an extra gun that's relevant is always unfairly prejudicial? It can't be so, right? But it seems like what you're saying is, and I could get on board with the child pornography always unfair sort of situation. But to me, it gets kind of challenging to write a reversal that says, yeah, trial judge, it was relevant. We agree with you there, but we disagree with you. And we think that you abused your discretion because it's unfairly prejudicial because it was a gun. That's hard to write, isn't it?
I don't think so. I think John Bear did it. They said even if it's relevant, like the one gun is too prejudicial. And I disagree. That's an abuse of discretion. I mean, the case law says generally the admission of evidence is abuse of discretion, but the application of case law on the issue is reviewed de novo. And it's our position that the case law, John Bear, Downs, Sosa, and the Agathias case all support a reversal in this case. So you should review de novo based on that case law.
And so I'm interested in the gun argument, clearly. I'm also wondering if it might be a red herring for two reasons that I'd like you to address. Number one, the jury found he wasn't the shooter, right? They made a special finding. He didn't fire a gun, right? So they, to me, pretty clearly convicted him based on the principal instruction.
I think that's fair.
And so to what extent is the idea that, well, he had the gun, he must be shooting people? Like whatever the prejudice or improper admission of that gun, your client won that issue. They found he didn't shoot anybody, right? I mean, that the jury believed your side of it. He didn't shoot anybody. So does the idea that they convicted him based on propensity to shoot somebody, does that kind of just a red herring? Because the gun makes him think he's a guy that shoots people, but nonetheless, you won that issue. The jury found he didn't shoot people. The second thing is the special interrogatory that he possessed a firearm was there for a reason, right? I guess that had to do with the enhancement of the crime. So they convicted him based on the principal theory. If he was convicted based solely on the principal theory, right, that whatever the enhancement was or the classification that involved him possessing a firearm and the use involved him to actually use the firearm, and here's what I mean by that. Assume it's just straight principle. He's texting somebody and saying, hey, shoot this guy. Okay.
Sure.
If the statute is, hey, if you possess a gun in the commission of a murder, even if he was nowhere near the murder scene, if he had a gun on him when he was sending that text message, that makes the gun independently relevant, right? Now, if it's you have to use the gun, maybe less. So where does that fall, right? Because he was not convicted as the shooter, right?
Right.
But if the way that statute works is that if he possessed a gun and he didn't actually have to use it in the commission of a crime, to me, that makes the 5-7 independently relevant, right? Because it was in his car. That means it was within his control. If he had that gun within his control when he gave the order to shoot the victim, wouldn't that be independently relevant?
Well, let's start with the evidence. There's no evidence that he texted anybody to shoot.
But he was convicted as a principal,
Right.
So the jury made that inference.
So we would suggest that the evidence on principle is weak at best.
Assume I disagree with you on that. Assume I think the principal instruction was proper and that there was competent, substantial evidence. And the jury, in fact, found on the principal instruction, which it looks to me at least like they did, right? If the law is, hey, you are guilty of this extra enhancement if you possess a firearm while killing somebody, even if it's only as a principal, even if you're not the shooter, well, then him just having the 5-7 in his car is independently relevant, right? So I mean, am I seeing an issue that's not there? Feel free to point it out if I'm not, but that special interrogatory was there for a reason, right?
Well, it's there for the 10-20 life minimum mandatory.
Exactly, right?
So-
And that only requires that he possessed the firearm when he did the crime, right?
Correct.
Okay,
That's the 10
well,
minimum mandatory, yes.
okay. So if the 5-7 was in his car That's possession, isn't it?
Arguably, I mean, I don't,
Okay.
I don't know.
So it doesn't have,
I don't think so under these facts, but
I guess it doesn't have to be the murder weapon to be relevant to the 1020 life, does it?
that's correct. But it's not, it's our position under the facts of this case. It's still not relevant to any issue in question.
One of the issues in question was, did you possess a firearm? That was an issue in question. Huh?
Pursuant to the top of interrogatory, I don't know that it should have been.
Well, you didn't appeal that. Nobody appealed the
Sure,
special interrogatory,
sure.
so that's not before us.
Agreed, but
There was one of the issues in this case that is right or wrong. It's unappealed. It's not appealed. Did you possess a firearm? Didn't say, did you possess a murder weapon?
sure.
It was, did you possess a firearm? So that would mean to me any firearm. Am I missing anything?
Not on that issue, but I think that the fact that he was convicted on the principal theory makes the
Does the 1020
error-
life, I guess what I'm asking you is, does the 1020 life part of the statute make any distinction between being convicted as a principal and convicted as a shooter?
actually it does. It does. It says the 1020 life law, you have to actually possess the firearm.
Possess, not use.
Right, sure.
Okay,
I
it
mean,
doesn't say you have to use it, it says you have to possess it.
Sure.
Does it say you have to be the shooter? Does it say it doesn't apply in principal cases?
it says you can't be found guilty if someone else possesses it, but if you possess it, then
Okay,
it
but
applies.
you don't have to possess the murder weapon, you just have to possess a firearm.
Right, right.
And there's nothing about the 1020 life statute that says it doesn't apply when you kill somebody by telling someone else to do it, right?
Right, but we don't have any evidence.
So in other words, if somebody texts somebody else and says, I want you to do a murder, right? Murder this guy for me. And he possesses a firearm while he sends that text. Firearm has nothing to do with the murder in the sense that the person who does the shooting doesn't use that firearm. He would still be guilty and the 1020 life would still apply to the guy who sent the text, right?
It would. And I think the difference here is that the evidence on principle is extremely weak. So you have that firearm, which I think relevance is minimal, but then you also have the additional ammunition evidence in exhibit 31 that he certainly wasn't possessing.
But it seems to me your argument on the gun rises or falls on whether the principal instruction was proper. If the principal instruction was proper, then any guns he possessed are relevant
And
directly and clearly.
and as noted in our briefs, we don't believe the principal instruction was correct.
But I guess what I'm saying, is there any way we can find against you on the principal issue and find for you on the gun issue? Can you think of any? Based on how the 1020
Yes,
life
I think you
statute is?
introduced both the firearm and then a wealth of ammunition evidence in exhibit 31. So that was inadmissible as well.
But if possession of a firearm is at issue, any firearm, not just the murder weapon, isn't all of that relevant?
I don't think position of an ammunition is relevant. Like it's a firearm, it's not ammunition, and there's
So that would, but then,
there's 7 or 8 pictures in exhibit 31 of
But-
ammunition.
but then it would be based on the idea that the ammunition on its own was independently prejudicial beyond the firearm, because the firearm itself is directly and clearly relevant to the 1020 life.
Assuming, yes, I agree.
All right, thank you.
Well, counsel, it looks like you'll get some extra time if you need it. Thank you, Mr. Purnell.
Judges like to talk, shocker.
You may proceed.
Thank you. Lawyers like to write. My name is Robert Bradford. I represent the state of Florida in this matter. Good morning. Judge Mize, in answer to your question, I was trying to go back and think of why this was a Glock 40. And if I remember correctly, and I'm not saying 100% this is the testimony, but as I recall, either the FDLE expert or one of the detectives, somebody testified as to the position of the firing pin in the primer in the shell casings, and they said it was a telltale sign of a Glock. I think that's what it was, where it was the ejector markings on the shell casing. There was some kind of connection. I remember the telltale signs of a Glock.
Did that get admitted?
Yeah, it was during the testimony at trial.
This had to be the FDLE analyst then. So like in the 800s on the trial transcript.
I didn't go back and check it. I didn't have the transcript in front of me, so I couldn't swear to that. But as I
said, the
recall,
firing pin of the gun.
there was
tell you what kind
something
of gun it was.
about something about the shell casing that told them it was a Glock that had spent this casing out. I don't remember if it was the firing pin position vis-a-vis the primer, or if it was the ejector markings, or if it was something else, but there was something. They knew that it was a Glock.
All right.
I'll jump right in to the first two issues as I even though with the extra time, I'm not sure I'm going to need to talk about it. Number three, I would just submit is without merit. Our attorneys can argue reasonable inferences, period. The fourth issue, the acknowledgement that Mr. Smith or that appellant had been read his rights before, heard his rights before, goes into something that I think applies to all of the harmless issues with respect to any of these evidentiary concerns. And that is the fact that the state's whole premise in this case is that Mr. Smith was a drug dealer. That he was a drug dealer, and apparently he was a pretty successful drug dealer because he drove a BMW with this James Bond-like modification to hide whatever in his dashboard. But he also
What does it have to do with success of being a drug dealer?
we also lived in a gated community. He could afford to pay for these things. He also
I
had,
know,
as
is there
I
some, is there
recall,
some evidence that installing that secret compartment costs lots of money?
well, the success being that he owned a BMW more than really being an elusive brand, along with this modification of the standard BMW. So he's spending money on top of spending money. So I think that does suggest it. Also, the fact that the victim's girlfriend and one of the, I think it was Benia, who testified that the victim had stolen guns and drugs from Mr. Smith's auto detailing shop. And if he's an auto detailer, I guess this goes back to the successful drug dealer part. He living in a gated community, driving the BMW and washing cars for a living just doesn't comport. It doesn't jive. So he has to be pretty.
So wouldn't you have to have some evidence as to how big his car detailing business was, what the profit was? Was there anything in there that actually supports what you're saying right now?
$17,000 worth of guns and drugs. Yes.
Well, yeah, what I'm saying is, without some evidence as to how much money he was making in the car detailing business, you don't know whether he could afford those things apart from selling drugs. It seemed to me to be something you're just saying now.
Let me back up. I think the evidence supports the reasonable inference that he was a successful drug dealer. Other than that, let me just back up. This whole my argument works without the fact that of him being successful. The fact that he was a a drug dealer, and the fact that he had been ripped off, his business had been burglarized. They stole a safe, they stole guns, they stole drugs. All of that was told to the jury. So hearing that he has a 5.7 handgun in that secret compartment in the BMW, I don't think carries the same weight with respect to propensity and bad character that it would say in the Althea's case, where 5 years after the murder, he's arrested and he has a gun on him. And so they admit that gun that has no connection.
Are you on harmless error already? I don't understand how this fits in. Are you conceding there was error here?
No.
Why are we talking about this? Are you doing, I don't understand where in that hierarchy, relevant, unfair prejudice, harmless error, what you're saying fits. It seems to be, I wasn't sure at all until that last comment. It seems like you're saying, if this was propensity evidence, it's minimal propensity evidence?
Okay. I had said I'd eliminated the third issue. I went to the fourth issue, which was the statements of I've been read my rights before. And that also is subject to a harmless error analysis. And that's simply what I was talking about. But the harmless error, I think the harmless error analysis permeates not from just that issue into the other issues. And it does apply to the gun issue. It does apply to the gun issue.
But I guess what Trevor's saying is it's a little odd to go to harmless error when we're trying to figure out whether there's error. Clearly, we're all interested in the gun issue.
And very well. Let me go back. I'll try and restate that a little more clearly. With respect to the official or the standard of review and the relevance, and I think what you were talking about earlier, I think it all is the same. I think there is a relevance consideration. I think there is the sufficient link consideration, but I think it's more of a combination, if you will, of the 401 and the 403, because you have to take into account the defenses that are presented. Some of these cases talk about the fact that it's whether it's relevant or whether it's that objectionable has to go with the defense that's been presented.
I'm not sure I understand what you just said. So if we look at 401, just the plain text of it, it's a definition of what relevant evidence is. And then 403 talks about when relevant evidence is inadmissible. So it seems to me to be a two-step process, that if it's irrelevant, and I think that this is O'Connor and Hune and Banks and all of the other DCA cases, they basically don't get to 403. John Bart might a little bit. O'Connor does, but only as it relates to the bulletproof vest. Like when we're talking about 401, every single one of those cases seem to me to say, look, it's irrelevant. It has no connection to the murder at all. It was in a backpack that they found 5 years later. It was in his waistband. So I don't understand how you can lump them together.
Well, I think, honestly, I think the courts have, there's certain opinions. I read a couple of those exactly the same way. For example, I think it was in Downs that said, you know, the gun wasn't tied to the crime. It wasn't tied to the defendant either. It had absolutely no relevance whatsoever. But then they go on to talk about how it's unfairly prejudicial. So even though they're saying it's not irrelevant, it's also prejudicial. Whether they use that under a 403 analysis or not, I couldn't tell you. Now, Gene Bart obviously does, because they said any marginal relevance was definitely outweighed by the danger of the unfair
It
prejudice.
just really seemed though, like in Gene Bart, I guess we'll call it that.
Sorry.
No worries. I'm not sure I'm pronouncing it the right way. So in that particular case, it wasn't relevant for what it was offered for. So in other words, in Gene Bart, they're saying this is, if you're going to say that this was relevant to prove that the defendant was the driver, how come you get to introduce it when it's found outside the passenger door 2 car crashes later?
Right. And Gene Bart, the court held that the gun was not probative of whether Gene Bart knew or did not know that his co-defendant was going to take those shots. He's the one, if I remember correctly, saying after the second shot went off, come on, let's go. And you're doing dumb stuff right now.
Right. But what if the proffered reason is just to say, like, yeah, obviously, like we've got an eyewitness, a victim who says that Mr. Gene Bart's the driver. What would be theoretically wrong with the state saying, yeah, you know, they're going to impeach him based on his his stress at that particular circumstances, his line of sight, maybe the fact that he wore really thick glasses, all the things that you saw on like My Cousin Vinny. But what they say is, if they'd have said, hey, it's just to show that he was in the car, how is that not relevant then?
Well, I guess there has to be a dispute that he was in the car. I mean,
Right.
in John Bart, there were, I don't think that was a dispute. There was no dispute that he was in the car.
Yeah, I might not have phrased my question terribly artfully, but it seems to me that the way that I read Gene Bart is the state said, I want to prove that this gun outside the passenger thing proved he was the driver. And the trial court just said, what are you talking about?
Well, his defense apparently was that he did not know what was going to happen.
Yeah.
So he's even acknowledging he was there.
Fair enough.
I didn't know what was going to happen. I didn't know he was going to do that. Yeah, I drove it, but I didn't know.
Yeah, and in that sense, the gun's irrelevant.
Right.
So you don't reach the prejudicial
Yeah,
analysis, although we've got this statement and it like starts in O'Connor and Gene Bart picks it up, which just basically says somehow that something could be completely inadmissible and still somehow get in under 403. And I don't see that based on 403's plain language, because it just talks about when relevant evidence is inadmissible. Do you follow?
Right. Yes.
Okay.
Yeah.
I just think the case law is confusing on that. I'm not sure it's right.
Right.
Counsel, am I right about the 1020 life statute?
I think so. Yes. I don't disagree with you on that.
Well, if that's the case, what's the competent substantial evidence for principal theory?
For principal theory, all right, the murder weapon was at the very least a 40 caliber, if not a Glock 40. He had a Glock 40 box in his house. He had
Now, the Glock 40 box had a test round in it that did not match the murder weapon, right?
well, I believe there was the elimination
That was one thing I thought was interesting, right? So, handguns typically come with a test round. That's supposed to be a test round of that gun to show you that it was test fired and worked, right? And in this case, the Glock 40 was missing from the box, but the test round was there and it didn't match the murder weapon. Now, it doesn't seem like that was really explored at trial, right? Because somebody would have had to establish that, that's Glock's procedure and that test round applied to the gun. But in fact, the test round didn't match the murder weapon. That would seem to indicate that the missing Glock, whatever you thought about it, was not, maybe some Glock 40 was a murder weapon, not that Glock.
Well, I think 2 witnesses testified as to gun manufacturers putting in a couple of test rounds or a couple of shell casings in the boxes when they sell it to show that the gun was working.
I read it,
But they also said that you could not prove it. I mean, that's just what gun manufacturers claim. And one.
Well, that's the point. Somebody
witness said
would have had to call Glock, right?
Well, even then, you can't prove that what Glock's telling you is correct.
Yeah, but I mean, to go through the business procedure, right? I mean,
Sure.
my point is it could have been explored. I think when I looked at the transcript, the person basically said, I think that's what they do, but I don't really know. That is in fact the industry practice. Right? You buy a new handgun, it's got a test round in it. It's supposed to be, assuming the manufacturer is following what they're supposed to do, it's supposed to be a test round from that gun. So
I honestly, Your Honor, there was no evidence of that at trial. I personally, just from my own experience, I bought one brand new gun in a box in my life, and I don't recall it coming from any shell case. That was a long time ago, but I don't remember that. But like I said, that was not presented at trial. The only evidence presented at trial was the fact that those were supposed to be theoretically, but that could be proven. Nobody really knows for sure.
What's the competent substantial evidence for principal theory?
Oh, well, let's start with the Glock 40 magazine in his car, the empty box. He had communicated all day with Bonilla when the defendant himself says Bonilla is responsible for this whole thing. Bonilla confirmed that the victim was the one who ripped you off for $17,000 worth of guns and drugs. So he had the motive. He's the only one with a motive. He was present at the Shell station with Bonilla, with Wood, with Leonard. He was told that his car had been spotted by the victim, and he said, give me 30 minutes. And then a few minutes, however long it was later, he said, I'll be there. I've forgotten if it wasn't, he says, I'm on my way. I'm on my way. Not I've sent, even if he said I sent somebody else, that's still enough. He texted his nephew the ominous message, this stuff ends today, but it didn't say stuff. I'm going to handle everything. And he also searched for news of the murder on the internet hours after it happened that evening. So he drove from his gated community to the area of the murder in a timely fashion. He was in the murder area. He returned to his home in a timely fashion. There was a lot of circumstantial evidence that said he was the principal. He could have been. Now, the jury would disagree. He could have been sitting in that red Hyundai, either in the driver's seat or in the passenger seat, and shot the victim. But at the very least, the jury was convinced that because of the circumstantial evidence, he at the very least provided the handgun that was used in the murder to kill the person who had ripped him off.
We don't know the jury. We know the jury concluded he was a principal, at least I think. That's how I interpret the verdict.
I do too.
We don't know that means he thinks he gave him the murder weapon.
I'm sorry.
We don't know that means the jury thought he gave him the murder weapon. I mean,
No,
that's a possible thing the jury concluded.
Correct.
We don't know the jury concluded that.
But I mean, all of those things, he spent the entire day setting this up with the name. He's a principal. If he's not the shooter, he's a principal. That's the competent substantial evidence. There was plenty of it. As far as the cases that were cited in the brief, the Gardner case, which is a 5th District Court case, that was the one where he had robbed a store with a BB gun, or sorry, he had robbed a store, lifting his shirt up to expose the handle of a weapon stuck in his waistband. They arrested him, recovered a BB gun. The clerk identified that as looking like what I saw when he lifted his shirt. And the 50A said that was enough for that to come in. You don't have to prove it's the murder weapon. It just has to be sufficiently linked. Now, in that particular case, I would submit that the Gardner actually supports the admission of the magazine from the car and the Glock 40 box and the Glock 40 ammunition. Because of this, Gardner actually supports that. Now, with respect to the 5.7, it doesn't say that it couldn't have come in. It's just the central issue in that case was whether there was enough to admit that as the weapon. And so you did definitively prove it was the weapon. The state didn't prove that to get it admitted. They didn't have to. It was up to the jury to decide what weight and credence to give that evidence. And that's what the court said. We've already discussed John Barton Downs. There was the Green case. That where 5 men robbed and murdered a drug dealer using 2 guns, and the search warrant at Green's residence yielded 3 guns, all of the same caliber, but none of which were the actual weapon used, and they apparently proved that. 2 were not even found in his room. Obviously, that is propensity, that is bad character, that they're not tied to the crime, and they're not even, those 2 were not even tied to him. And the court said that, you know, even if marginally relevant, it was substantially outweighed by unfair prejudice. Marginally relevant to show that he possessed the same type of caliber of gun as the gun used in the crime or something along those lines. I guess that's pretty weak. The Oliver case, I think, is more instructive, where the Supreme Court, the Florida Supreme Court, said that a shotgun that had been traded for the murder weapon was admissible to link the defendant to the murder weapon. And so therefore they used one gun to link it to another, to the crime and to the other murder weapon. And I submit that's more in line with what the facts that we have here. You had the 5.7 gun with his DNA, although albeit it had 3 other sources of DNA on it as well. He could have said it wasn't mine. That's why the box and the shell casing, the box and the ammunition, I think, were also admissible to show it's his. But it has his DNA. It's lying next to the Glock 40 magazine in the secret compartment. I mean, it's not like somebody can toss it into his car through an open window. So, so all of that kind of plays out here. So I would submit that there's plenty of things to tie the firearm evidence to this crime. In addition to the Oliver case, there was the Johnson case. The Johnson case talked about how it was relevant to support or corroborate another witness's testimony. So there's apparently a myriad of different uses to make the evidence relevant. It doesn't have to be the weapon used in the offense. It doesn't have to be. There's no parameters other than a sufficient. That's all that's required. A nexus, a connection. And in this case, the 5.7 gun and its accessories were definitely connected. And then that brings us, I would submit, to the harmless error analysis, which, going back to what I was saying before, even if it was otherwise error to admit, I don't believe it was harmful error because of the state's overall theme of the case. The fact that he was a drug dealer exacting revenge on a purchaser who had ripped him off of $17,000 worth of guns and drugs. The jury heard that, and then they hear he had a gun in his car. I don't think it's the gun in his car that's going to make the jury convict him. It's the other circumstantial evidence, all the substantial evidence that I just reviewed with respect to the principal issue, as well as.
Remind me where the jury heard that there was a robbery of $17,000 of guns and drugs. The way that I'm recalling the transcript was it was a robbery of his mobile detailing business by virtue of the motion in limine. Are we remembering this differently?
Bonilla testified that he was the one who ripped off your shop. And
But I don't remember
believe
$17,000 of guns and drugs.
It may not have been $17,000. I know the victim's girlfriend testified that he came home because it was right before he left to go to Texas. I think he told her that he was going to do it because he needed the money. And then she said one night he came home with a safe and guns and drugs. Whether it was $17,000 or not, I don't.
Yeah, you made a couple of statements about what's in the transcript that don't resonate with my recollection. I'll check them.
Yeah, well, that's fine. With respect to the, the last thing I wanted to address with respect to issue one, counsel brought up the fact that during closing, the prosecutor made a comment that referenced the gun found and kind of reinforced the error or the prejudice. That was on page 1048 of the transcript. On page 1043, the prosecutor had begun that general discussion. She was talking about means and reminded the jury that it was a appellant that had the Glock 40 box, that had the Glock 40 magazine and a secret compartment in his car. The murder weapon was a Glock 40. The conclusion was the appellant had means, and it distinguished the fact that Vinny did not have the means. There's no evidence that he ever had possession of a weapon in this case. 5 pages later, he kind of goes back to that theme and says that the person that has a secret compartment in his vehicle that houses a gun and a magazine for the murder weapon is likely the murderer. Again, I don't think it's so much that he's emphasizing the gun in the car as he is the secret compartment and the Glock 40 magazine. I just on a greater scale, I think it's not as significant as it initially appears or is made out to be. The only thing I think I really haven't discussed is the last issue with Miranda. Since I have a little extra time, I'll get to that. Again, with all this, the same harmless error argument, that he's a drug dealer, that he has guns and drugs, enough guns and drugs, whether it was $17,000 or not, it was enough for somebody to burglarize. Okay, so there had to have been enough. Somebody had to know about that as well. The victim obviously knew about it. We don't know how the victim knew about it. The victim knew he had guns and drugs and shot him and burglarized it and left the state. Comes back a few months later, he gets killed. But whether he's had his rights read to him before, whether he's heard his rights before, I don't think the jury's going to convict him based on the fact that he's had his rights read to him. They didn't hear any collateral crimes. They didn't hear any conduct with respect in that statement. There was no conduct. There was no actual crimes mentioned. There was no circumstances around under which he'd heard the rights. No convictions mentioned. No offenses. In light of everything else that the jury heard about Mr. Smith, I don't think that made the difference and contributed to the verdict. So unless there are any more questions for me, I'll just ask the court to affirm the judgment set in small respect.
Thank you. Mr. Pennell, Judge Mize and I jumped all over your rebuttal time. Would you like to take, say, 3 minutes and just address principle for us? Because I think it bears on what your arguments are going to be.
That would be great. If it's okay, I'd like to address the 1020 life issue real quick. But
Sure.
So I think that solely to prove the 1020 life possession, as a matter of law, the 5.7 firearm found in the glove box would not have been admissible. And the reason for that is if you look at the definition of the actual possession in the instructions on page 139 of the record, it says to actually possess a firearm means that the defendant carried a firearm in his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. This firearm was found in a compartment in the back of the glove box. There's no evidence that it was within his immediate physical reach.
But we know he was in the car that whole night, right? And we've got the GPS and the phone signal, and he was driving around in the vehicle. So,
Yes.
So he's in the vehicle, guns in the glove box. You don't think that meets the definition?
I don't. It says immediate had a firearm within immediate physical reach with ready access. So I can
reach my glove box from my driver's seat really easily.
No, I understand, but now we're one step further than that. Now we have a compartment in the back of the glove box. So I think it's more equivalent to the trunk now. Like, I don't think it's an immediate physical reach.
Doesn't that depend on how easy it is to open that, right? I mean, if they're, say, a passcode that took them 30 or 40 seconds versus just a little secret button on the side that pops open, right? Like,
My point is that there's no evidence in this record that shows it's in his immediate physical reach. So it would not support, so it would not be independently admissible just to show that actual possession. So I think the 1020 life issue we discussed is a red herring and doesn't make it relevant. As far as the principal, I think the state's evidence simply establishes that he's a principal to a meeting. He agrees in text messages with Benia to meet to go to the meeting. So we need a conscious intent that the criminal act be done. The criminal act is first degree premeditated murder. There's no evidence that he had intent to commit first degree premeditated murder. He says at the closest they get is, he says in a text to an unknown person named Neff, not to Bonilla, to an unknown person named Neff, this shit ends today. I'm going to take care of business. Just know whatever happens, I love you. All that shows is that he's going to meet up with the victim. Is he going to insult him? Is he going to recover stolen items? It's a jump to say he's going to murder him. Taking care of business is not saying I'm going to murder him. Does not suggest an intent to murder him. And we can't use the fact that the victim was subsequently shot, potentially by Bonilla, to support the fact that there was intent. You have to independently show that intent. So there's no evidence of intent to commit first degree murder in this record.
What about the fact that it's a red herring just based on the fact that the jury agreed with your client he wasn't the shooter, right? Because the whole idea of propensity was, you know, the extra gun shows a propensity to shoot people, and that's unfair and prejudicial. But whatever the prejudice or impropriety of that, your client won that issue. The jury found he was not the shooter. So like, what could be the prejudice if he won?
I hear you on that. Is the prejudice is that he's a bad guy because he has guns and firearms and ammunition. So we think he was around. We think he was involved. We don't believe Bonilla, the state's main witness. We don't believe him at all. We reject his testimony that my client was the shooter. But we think this guy's a bad guy, so we're going to find him guilty as a principal. Because the exact reason these cases are out there. And again, the prosecutor took advantage of it. To say that this statement in closing isn't improper and doesn't take advantage of this, it's just amazing to me. I mean, he says, we can't downplay the significance. This person that has a secret compartment in his vehicle that houses a gun and a magazine for a murder weapon is very likely the murderer. This is a textbook example of saying, because he has a gun unrelated to the crime, he's guilty of the crime. That's it. That's why we have this case law. This is why this evidence is admissible. That's why the evidence is harmful. And the fact that they rejected Bonilla's testimony and found him guilty as a principal as not the shooter shows that this is a weak case, and any error could have pushed a jury over the edge into finding him guilty as opposed to acquitting him.
Okay. I think you've addressed our principal question. Do you want to wrap up?
For those reasons, it's our position that the firearm was improperly admitted, and that the principal instruction was improperly provided. Again, we only have evidence of principal to go to a meeting. We're speculating that he had an intent to commit first degree murder. And for those reasons, we'd ask the court to reverse and grant him a new trial with the only admissible evidence before the jury.
Thank you both for the argument and the presentation. We'll take the case under advisement. Court will be in recess.